Good morning, good morning, good morning, amazing law nerd. It's Thursday. I think it's Thursday. It's Thursday. It's February 19th. I feel like I've been saying, oh my God, I can't believe it since the beginning of January. Where does time go? But it's Thursday. It's February 19th, 2026. We have lots of court to talk about today. Of course, there are millions of other things going on. Are we going to talk about them today? No, we're not. What are we talking about today? Kouri Richins. Why? Because my brain is ready for trial, and I bet yours is too. And yesterday when I went to pull the docket, there were so many docket items, and not all of them were sealed. I know. In this case, one never knows because so much has been sealed lately. It was really nice to see a docket that didn't just have everything sealed. So we have so much to go over. Also, did you guys get your shirts? Did you get your shirts? Let me know in the chat if you got your shirts. I hope you got your shirts. If you didn't have the Law Nerd app and waited until I went live to talk about it, it might have been more difficult. But if you had the app, it's going to help. Let me know where you're coming in from, what you're doing. I love seeing it. I also saw somebody ask, Sam asked about the ghost emoji with the coffee. A coffee emoji will be back. We are going to do some more seasonal emojis. The coffee emoji will come back, but we're going to do them seasonally, and we have been kind of varying them as we get into new launches. So also, let me know where you're coming in from, what you're drinking. Californians, I see that, at least the streets around the old courthouse I used to work at were completely flooded. Stay safe, stay dry, and when the water looks deep, don't drive through it. I know that's weird to say, but it doesn't happen that often in California. So, also, towing people on boogie boards, surfboards, wakeboards, any type of board, really, rollerblades, skateboards, behind a vehicle when it is wet is really dangerous, and it is something that can lead to charges. So just be mindful and warn the teens that even though it seems like there is no difference between towing someone on a boat on a water ski and towing someone on a truck on a water ski down the street are the same, they are not the same. Just a reminder, not the same. I get where the thought process is. Not the same. Just go to Lake Elsinore. It'll be fine. All right. Shall we? We are going to roll the intro, and we are going to talk all about Kouri Richins. All right? I'm going to roll the intro. I'm going to put up a poll too. Ready? Let's go. Wait, Emily, the sound's not going to the right place at all. Hold on. That was me because I was catching up on things and I didn't want to have my in-ears in. So I put the sound in the wrong place. It's fine. We'll fix it in post. Hey there. I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right, y'all. And I put up this poll to ask if you've been following this case. If you have not, no shade, and I kind of love it. I love that there are new law nerds that are like, this is my first exposure to the case. What are we doing? Let's ride. This case has quite a history on this channel. We have been covering it since like May, maybe June, but May of like 2023. So we're almost 3 years into covering this case, and we have had so many like court hearings. We watched multiple days of a preliminary hearing. There was an extensive, I don't remember if it was multiple days, but there was an extensive bail hearing with witnesses and evidence. There were suppression hearings with witnesses and evidence. So we have seen a lot of hearings in this case. And so for those of you that are just like, oh my God, what is this case? I want to get you caught up, but also I don't want to spoil some of the moments in this case that might be new, because there is something delightful going into a case where you are surprised. I remember in Depp Heard when Amber Heard had given a deposition and had like literally tried to clock back like, Oh my God, I can't believe I just said something about giving it to TMZ or telling the reporters or whatever? A lot of people had seen that online. I hadn't going into the case, and I was stunned. And those in the chat were like, oh my God, how did you not know this? And I'm like, I have not been on the internet looking for information about this case, and I didn't follow the court proceedings, and there was no video of the court proceedings in advance. Also, I need to clear something up in the chat. I did not diss Lake Elsinore. I was saying that you can't go pulling, using a truck like a boat around the streets of LBC. I said, go to Lake Elsinore, go get on a lake. Like literally go jump in a lake. Go to Kern? Is that better? Go jump in Kern. I was just trying to exemplify that you could actually go do lake things. There are lake things to go do. That's all. Instead of sending people to be like, I don't know, go to Havasu. Because I wasn't dissing Elsinore. It's just a go jump in a lake for fun, for recreation. Flooded streets are not for fun and recreation, right? So no diss to Lake Elsinore. That's where we used to go. Aaron Almighty said Elsinore can take strays because it's Elsinore. I mean, that's also fair. Mm-hmm. Also fair. We could just give a shout out to Kern. Forget it, Elsinore. Too late. All right. So as we talk about this case, I am trying to keep in mind that there are a number of law nerds that do not know this case. You are going to see, what are people going to call this case? What is the media going to call this case? If the media ever stops covering anything other than Nancy Guthrie, if there's coverage of this case, what is it going to be called? I don't know, the children's book killer or something? Because yes, in the time between Kouri Richins calling 911 and saying that she just walked into her bedroom and her husband was non-responsive at 3:00 in the morning or whatever, and her getting arrested over a year later, because it does seem that there were some difficulties in, getting into her cell phone and they needed the FBI's help with that. She wrote a children's book about grief, and she ghost wrote a children's book about grief, but she wrote a children's book about grief. And she was sharing that children's book about grief on her social media and on local media, and that children's book is now part of a civil lawsuit, and there are multiple prongs of litigation going on to the side of this murder trial because there was a lot of litigation going on over the estate of the victim, in this case, Eric Richins. So part of the murder trial here is the financial backstory and the fact that she didn't know that the will had been changed so that if Eric died during the marriage, she didn't just get like a part of his very successful business and the house that was in his name and other things. She didn't know that. And when she found out, she did not take that news well. She had miscalculated how much money she would get and how much money she would receive from the deceased. We also learned in the course of this that not only was there the children's book, which is the subject of litigation, there's other litigation going on. We will look back at the civil litigation going on around the estate of Eric Richins after the criminal case, because everything is essentially paused right now because of the criminal case. A lot of you are saying you think that the media will call it the Moscow Mule murder. Fair. And the defense gets so feisty about that because the defense says, we don't even know it was a Moscow Mule. I mean, she said she also made a lemon drop. Okay. So as we have seen this case progress, there is the financial component of it. We're not going to see nearly as much of that as we saw in Murdaugh, but there is a financial component to it. There was also a charged attempted murder from Valentine's Day 2022, saying or alleging that Kouri Richins tried to poison Eric Richins on Valentine's Day with a fentanyl-laced or opioid-laced breakfast sandwich from a local breakfast spot where she went and got breakfast sandwiches and then left it for him. We're going to hear about text messages in connection with that. There is some pretrial litigation going on about what Eric Richins' friends can testify to that they knew from him, and whether that is a present sense impression, and whether some of the information from Eric Richins can come in from Valentine's Day. And then on March 3rd, in the overnight, March 2nd to March 3rd, he died with a significant amount of fentanyl in his system. She has said in jail letters that we have seen in the Walk the Dog letter and elsewhere that she is alleging it was a like fentanyl laced gummy. And then they tested like all of the THC gummies and none of them had fentanyl in it. And then it was like, oh, the Walk the Dog letter was like, he's always doing this and he's always doing that. And she says the Walk the Dog letter is part of a novel, very in-depth novel. It's a novel. But the Walk the Dog letter seems to be, Mom, brother, I need you to go tell my lawyer this, because this is the defense that we want to go with. And I need you to testify to this to tie that together. Okay? So today we're going to look at the ruling about the Walk the Dog letter. And when we get into this case, we are also going to see rulings today about the journal, because she journaled about it. How very Ruby Frankie of her. I know. She journaled about it. She's going to hate that comparison. Not as much as she hates the fact that the news cycle is only talking about Nancy Guthrie. Oh, the things that are going to piss off this defendant. Becky RN clocked it in the chat. I was thinking this yesterday. She'll be so disappointed. She is going to be so mad. She is going to be so mad that they have waited for trial forever. And it is not even going to be the top news story in Utah because the news has moved into other stuff. And stuff is going to keep happening that is going to pull from this. There will be news coverage of it, but nowhere near the news coverage that she might have gotten if other things weren't happening. And remember, she did ask her mom to try to get her lawyer to smuggle her in crust white strips so she would look better on the news. And then all of a sudden her defense attorneys started giving all kinds of interviews and trying to shift the narrative online. The narrative online is going to be talking about Nancy Guthrie, Prince Andrew, yes, which we're not going to talk about today. But the news is going to be dominated by other things. 100%, law nerds, 100%. The Olympics, So there is going to be lots of other stories, and that is going to piss her off. So there's going to be a lot of really big news. But we are going to be covering gavel to gavel coverage because we are invested in this story. We are ride or die. We are not fair weather law nerds. We are not fair weather law nerds. We were planning for this trial, and we are going to trial. Even if nobody else cares, we are going to trial. We are going to trial. Oh shit, I've distracted the chat on myself. Sorry, chat. You guys have 3 minutes, and then we're moving on. Thank you, mods. That was my fault. Former Prince Andrew was arrested in the UK. It seemed, I don't know. I'm not in the UK. I do not know. I have not researched. I saw headlines and I went, I'll come back to this later. Am I surprised? Actually, with everything that is, even my camera is like, we're not covering this. I know. Was I surprised? I'm surprised that anything is happening from all the files being released. And you know what? Hopefully we'll see more of it, and it'll keep dominating the headlines. Hopefully we'll see more of it. I wouldn't be mad if we were getting news of arrests daily. It really wouldn't piss me off. But we'll see. But it is going to dominate the headlines. I am not following. But we'll see what happens. At some point, I'm interested to see if anything happens, and maybe this is something. So, good. Keep arresting people. It's not like there's not any evidence. Just keep arresting people. Go ahead. Just keep arresting people. Sure. Mm-hmm. And if the people that need to be arresting people are the people that need to be arrested, arrest them too. And then get other people to arrest the people. Sure. There's plenty of people that weren't powerful enough to be mentioned at all. Go find them. They'll go arrest people. It'll be fine. It'll be fine. Just go ahead. Either way, we are going to focus on all of the Kouri Richins stuff because we're going to trial. There's going to be a ton of other stuff happening during trial, and we're going to stay focused. So, Law Nerds, thank you. I know it was definitely my dissuading the chat. It's all right. It's a Thursday. It's fair. We're big fans of justice. And when people play in our faces, we don't like it very much. Yeah, it's real frustrating. It's real frustrating. Yentel says we need the Oprah of arrests. You get arrested. You get arrested. You get arrested. Yep. All right. You guys are the best. But this is why I spent yesterday sharing. Maybe we'll talk about it at the end. The other walk the dog that dominated the news yesterday at the Olympics. I loved it. And yes, they say that the dog that we'll do that first. We'll do a quick bit and then we'll get into Kouri Richins. Is that fair? Is that fair? Can we sidetrack for a minute? Sure. There's going to be one person in the comment section tomorrow that's like, it took you 45 minutes to start talking about anything. Excuse me. We have timestamps. Go to the timestamps and then just skip to the thing you want to skip to. Because if you're not here live, you don't get to decide the direction of the show. The chat is here for it. The chat's like, let us run. Let us run like a dog who loves snow. I know. I mean, dogs will hunt. Let's run real quick. Emily, you can't just Google Olympic doggo and expect it to come up. Yes, I fucking can. And yes, it fucking did. And yes, we're going to pull it up. Yes, we are. All right. Let's sidetrack real quick. If you follow me on Instagram, I try to share things that I am delighted by. And when I first saw the story, here, we'll swoop. We'll do a proper quick bit, y'all. Quick bit Sidequest. It's worth it. Look, if we have to cut it out of the replay, everyone's going to be like, what happened to a giant chunk of stream? It just disappeared. Let's talk about Kouri Richins. Can't we? Shouldn't we? We should. It's fine. It's fine. It's going to be fine. Everyone who is not on live is going to be really confused later, but it's going to be fine. We need to talk about avoid restrictions on YouTube live streaming. We have detected a video. Yes, I'm listening. I know. Yes. I stand by fair use because that was very valuable doggo commentary. I stand by it. However, the powers that be do not. Look, you could just invite me to give commentary and then we could all just work together. It would be great. All right. Kouri Richins. It's also topical because this is not what is meant by the walk the dog letter. This is not the walk the dog letter. We needed an example of what is a walk the dog letter and what is not a walk the dog letter. This is not the walk the dog letter that we were talking about. It's actually directly related to our case. This is what we wish the walk the dog letter was. Actual doggo sprinting and having the best time ever. But that's not what the walk the dog letter is today. We have numerous new filings and rulings from the judge. We have a prosecution resubmission of additional oral argument and remember the defense was asking the prosecution to compel disclosure of everyone's cell phone conversations. They were trying to go full Proctor. We talked about that. There's a ruling on that too. So we have a bunch that we need to go through today, but there is a ruling about that motion to compel. Your Honor, compel these conversations. It's sealed, not sealed. It's sealed, just it's not sealed. There's a ruling on that too. I think we're going to start with the state's supplemental briefing and then go in order of time. Oh no, just for giggles, we're going to go to the court denying a motion from the defense during jury selection. We are going to go through some of these quicker than others. Let's start by going to Utah. I feel like from Italy, we were in Italy, right? I feel like we were in Italy, at least in spirit. So from Italy to Utah is a good amount of frequent flyer miles, so we need to fly to Utah. Yeah. All right. Well, YouTube will behave, I promise. I understand that the robots, we have made them mad. I get it. We're going back to court now where we belong. I know. Just cover the court things. I hear you. So during jury selection, remember, Kouri Richins is charged with a first-degree murder, attempted murder, and a few other charges relating to fraudulent documents, etc. This is, yes, a serious case, but it is not a capital case because the state is not seeking the death penalty in this case. So it is a felony, but non-capital felony. That means that they do not get 12 jurors. If that sounds weird to you, I know it just depends on where you live and what jurisdiction you're in and how many jurors you get. You don't always get 12 jurors in a criminal case, depending on your jurisdiction. But in Utah, you get 8. 8 deliberating jurors, and then however many alternates. In this case, the court picked 4. So technically, you do get 12 jurors, but just not 12 deliberating jurors. You get 8. So the defense made a motion for more peremptory challenges, which is a great time for us to talk about peremptory challenges. Emily, what is a peremptory challenge? When you are picking a jury, you have challenges for cause. If a juror raises their hand and is like, yeah, that person sitting over there, their face looks guilty. That's probably a challenge for cause. Hey, Your Honor, this person hates my client's face. They can't be fair. Sometimes you have jurors that come in and are like, it is against my religious belief to sit in judgment of another human. I cannot render a verdict in any case. So you are unable and unwilling to sit in judgment of another human and you will not deliberate on a juror. Correct. Okay, that's for cause. You cannot be on this jury. Hey, Your Honor, I have plane tickets to Italy in 4 days. And I'm going to be gone for 3 weeks. That's cause. You cannot sit on this jury. You are not available. Goodbye. There are other things for cause, and some of them are much more sad. When you get into cause challenges, this happened a lot in the DUI realm when I was doing DUI trials, and especially DUI homicide trials, that a lot of jurors had a close friend, immediate family member impacted or killed by DUI. And they're like, look, I am happy to sit on jury duty. I cannot be objective in this case. I can't. The charges alone, I cannot sit here. And that's for cause too. Hey, you'd be a great juror on a case, not this case. Same with someone who had been a victim of pick a crime and the trial was for that exact crime. It's like, look, if you want me to sit on a jury trial and decide something else, I can, but this is just too close. I cannot be on this jury. Fair. Those are for cause challenges. There is a reason. Those are as many as you need because the juror is being removed because they, due to some reason, cannot sit on that jury. Also, with cause, you can end up with things like, hey, for a couple years after my spinal fusion, I could not sit in court that long. There's no way I could sit on a jury for 8 hours a day after my spinal fusion. It would have taken me a much longer time to be able to sit there. Medical reasons can be cause too. Hey, I actually cannot physically sit this long on these awful chairs. So, cause challenges are unlimited. They go to the particular juror and the particular things that juror has said. And sometimes you will see attorneys that will say, Your Honor, this juror said that they had a dentist appointment 3 Thursdays from now at 2:00. They can't sit on the jury. No, we can accommodate somebody who has a dental appointment. You don't get to use a for cause challenge just because you want to get rid of juror number 7 and they have a dental appointment in 4 weeks. We can just break early that day. No, that's not a for cause challenge. All right. So there are times that attorneys who might not love a juror and there is like a little something there, might argue that they should be removed for cause or kicked for cause. And the judge will be like, no, that's not going to work. No, you can use a peremptory if you want to, but you can't get rid of them. Peremptory challenges are limited. Peremptory challenges are a freebie. Peremptory challenges are like discard to the pile and pull the next in order, to use, card game analogy. You get to discard a juror and pull the next in line. Hopefully that makes sense. You get a limited amount of those. They can be for any lawful purpose. You cannot discriminate against jurors for race, religion, gender identity. You can't just kick someone for improper purposes. And this works. Jure said, yes, there's cause because I hate him. Oh yeah, if you have a juror that's giving you a stink face because they might hate you, you can get rid of them for that. If you had a juror, I had a juror I kicked for cause ages and ages ago because they were explaining that they were incredibly stressed because they were just about to go into finals week. And they indicated that they were stressed and worried that, I think they were like a freshman in college, that they were going into finals week and they didn't know if they could pay attention on the trial, and the judge would not remove them for cause. So I used a peremptory and removed them. I was like, good luck with your finals. Like, come on, Your Honor, really? They're obviously stressed out about finals. It legitimately is finals week, like in 3 days. I think that's good cause. Let them come back on jury duty another time. And just, yeah. And I was just like, thank you, juror number 7. Good luck on your finals. I didn't say that. My face probably did. So I thought that should have been for cause. It wasn't. I used a peremptory. You can use peremptories for things like that. There are times I use peremptories on engineers. Sorry, engineers. But when an engineer starts talking about what beyond a reasonable doubt means to them, especially the ones in the aerospace industry, they work in a field where their level and threshold for error is so high, because if they fuck it up, it can be catastrophic, that they're like, prove to me beyond a reasonable doubt is not the same level of anybody else's reasonable doubt. It is to a certainty and beyond. It is not a yes, step A, step B, step C. It is I need 17 people to tell me that bolt has the appropriate load for whatever the thing is. I have also found that, sorry, engineers, when you are interacting with normies, you don't always interact well with normies in a decision-making process. So I have found that for engineers, and I worked in an area where there was a lot of aerospace and there was an Air Force base and I found that it was like the worst group project in the world for the engineer and for all 11 other jurors, because they have to make a decision together. And trying to get an engineer on the same page as 11 normies is frustrating for all involved. And so I have also had engineers where I have afterwards been told how difficult deliberations were by the members of the jury, because it was very much you all aren't understanding what I'm saying, and I am very comfortable not changing my mind. Engineers will not be swayed. Engineers aren't going to change their mind. Engineers are very comfortable. Engineers are very comfortable sitting in a room of 11 people going, but you're wrong because, and saying, nah. You can think that, but I am correct. So you can all keep doing, like, if you all want to keep doing that, we can keep doing that. I'll come back tomorrow, but I'm not going to change my mind. So there are times when you look at a jury pool and you look at how everybody interacts in the world, and you're like, they're not all going to get along. Now, If I had a products liability case where the product was bad, bring me all the motherfucking engineers. Bring me all the engineers. They're going to get it, and it's going to be in their wheelhouse. But in a very human case that is criminal and is more emotionally based, nope. Products liability, yes. Trademark, yes. Any kind of civil case where the letter of the rule is the thing they need to decide, go for it. So I'm not saying no engineers never, but in some cases, no. Teachers, there are some lawyers that do not love having teachers on their jury. I have found the exact opposite. Love having teachers. Teachers are problem solvers. Teachers are used to listening to everybody's side of the story. Teachers can suss out bullshit faster than most. Love having a teacher on the jury. You know what else they make? Teachers make excellent jury for people. They make sure everybody gets heard. Sometimes and often they bring snacks. And the juries tend to have a good experience because there is somebody who is very used to wrangling groups of people with all different experiences, all different types of processing, and wrangling them in and make them work together. Perfect. Love a teacher. There are some lawyers that are like, teachers are too forgiving. They're not. Teachers will call bullshit when they need to call bullshit. However, if you try to bullshit them, they'll call bullshit on you if you're the lawyer. So yeah, some lawyers might not like that. So when we're talking about for cause versus peremptory, lawyers will use their experiences with past juries, their own experiences. I can see when people wish I would shut the fuck up. You're going to be shocked by this. I can't always help it because ADHD, but you can tell if a particular juror might not vibe with you. That's perfect to use a peremptory. This juror isn't going to vibe with me. Fine. Sure. That's good for a peremptory. So when you get peremptories, it just depends. Wendy Trauma Warrior, I loved having nurses on jury. It was often difficult to have nurses on a jury because in Southern California, there weren't enough of them and their work schedules were insane. And for a lot of them, they would come in and be like, missing work is going to be incredibly difficult for my life. And so it was difficult to have nurses on juries because of their work schedule. And they often would ask to be excused from jury duty because of how busy they were. So it depends on the person and the situation. So it also depends on the case and it depends on the lawyer. So peremptories, you get a limited amount. In Utah, you get 4. 4 peremptories. So with 4 peremptories, you, this is funny. So, wait, where is this? I just want to grab this chat real quick because this is so true. And I think it is, I've lost it already. Who was talking about 911 dispatch? There we go. Julie was saying, I cannot do jury duty. No one wants a 911 dispatcher. Julie, I think it is probably to their detriment because you also have great bullshit detectors. And people who work in law enforcement don't necessarily just trust law enforcement. And I think defense often is like, oh, you work in law enforcement, so you're out. I don't necessarily think that's true. However, you can't sit on a jury for the department you work for. That would be difficult. So if you're in a jurisdiction that you work for the only department in that jurisdiction, you're never going to sit on a jury because you can't sit essentially with your coworkers, if that makes sense. So let's get to the judge's ruling. The defense was asking for more peremptory challenges. And just to close the loop on our poll, and Emily being super chatty today, we had 17% of you that have not heard of this case yet. Yeah. So let's get to the defense asking for more peremptory challenges. And again, how a lawyer picks a jury is going to be based on them. It is going to be based on the other jurors, if they are aware. Not all lawyers are aware enough to do this, but you're trying to build a cohesive team in a jury box that's going to listen to each other. And if you have personalities that aren't all going to work together, sometimes you use a peremptory to just make sure that the team can work well together. You can't have too many chefs in the kitchen. So I had one jury and I'd run out of peremptories, and I had a juror sitting there staring at me. I'm like, shit, this isn't going to go well. That jury hung 11-1. And when the jurors came out to render their hung verdict, 11 jurors came out and this one. 11 jurors came out like this. And this one bopped into their seat and just sat on down. Happy as could be. The other jurors were so fucking pissed. And afterwards, when the judge said if he would like to talk to the lawyers, 11 of them came up to me. They were still like this. And were like, would not listen, would not deliberate. I was frustrated because there's a jury instruction that says if you have difficulty or someone refuses to deliberate, we can replace them with an alternate. But nobody remembered that, and that's okay. We ended up retrying the case, and it was fine. But 11 of them came out with their arms crossed, and the one was just like... But I knew it at jury selection. That one was going to be the problem, and there was nothing I could do about it. I was so frustrated. And so were they, and you can feel it. So you want to pick a cohesive group. Anyway, the defense wanted more peremptories. Let's take a look at that. This is ruling denying defendant's motion for additional peremptory challenges. Before the court is the defendant's request for an order that each side is entitled to 10 peremptory challenges. Footnote 1. Defendant's request was made as an oral motion on the record on February 10th, 2026. These things are set by statute. Some of you are asking, does it matter? Yeah, they're set by statute. The judge can't just like sprinkle them to the lawyers. These are set forth in the code. Literally, this is a stick to the code moment. And the judge can't just like bibbity boppity more preempts. You get what you get and you don't get upset. The law says. So the defense was like, but Your Honor, wouldn't it be great if we all just had 10? Under Rule 18D of the Utah Rules of Criminal Procedure, in a capital case, each side is entitled to 10 peremptory challenges. The number shall be 10. In other felony cases, each side is entitled to 4. Right. Big difference. Why is it a big difference? A, capital cases always get more peremptories. B, 12 jurors is more than 8. C, you're never going to get as many preempts as you need to sit on a jury. You need to pick a jury. You cannot just yeet people for days on end because you feel like it. If people have already been passed for cause, the only reason you should really be kicking them is if they, for some reason, you think they're not going to like your client, they're not going to play well with others, or they're not going to like your face. Those are your reasons. There are, of course, other reasons, but those are your main reasons. So no, you don't get a ton of them. Defendants, Molly said, I was very amused when my cousin, a DA in LA, was called for jury duty. Molly, I was amused when another DA in my office at a different courthouse ended up in one of my jury veneers and was just sitting there in one of my jury veneers. I was like, aren't you supposed to be in Norwalk? What are you doing here? And the judge is like, yeah, no. DAs can sit for jury duty because in LA, there are lots of city attorneys. So an LA DA can sit on a Hawthorne city attorney case. The defense attorneys are going to yeet them immediately, but it's not their case. But an LA DA can't sit on another LA DA's case. So you can go sit on a civil case. All right. The rule says you get 10 in a capital case, 4 on every other case. Defendant's request is based on defendant's argument that this case qualifies as a capital case under Rule 18D. I disagree because they're not pursuing capital punishment. Ergo, I'm never letting that go. Ergo, no capital case. Defendant is charged with, among other crimes, the court says aggravated murder under Utah Code 76-5-202 sub 2A. Quote, if a notice of intent to seek the death penalty has been filed, a violation of subsection 2 is a capital felony. But under Utah Code 76-5-202 3B, if a notice of intent to seek the death penalty has not been filed, aggravated murder is a non-capital first-degree felony, punishable as provided in other section. Life without parole. Pretty straightforward. No capital punishment, not a capital case. The court said upon filing of the original information and through the detention hearing in July 12th, 2023, the state was silent on whether they intended to seek capital punishment in the matter. Following the detention hearing, the state filed a notice of intent not to seek the death penalty. And then they quote the filing by the state. Accordingly, the matter involves a non-capital first-degree murder. That's it. The law says. So the judge denied the defense's motion. There's a caveat on that. And the caveat on that is when you get to alternate jurors, you generally get a few preemptories depending on how many alternates you're picking. So for your main panel, like for your core 8 jurors, you get 4 preemptories. You might get 1 or 2 preemptories when you get to alternates. That makes sense? All right. Let's get to the supplemental filings by the state on other matters, because this is what the judge's rulings are going to cover. I know we've done a very long law school lecture on the difference between peremptory challenges for cause challenges and some of the strategery around those decisions. We talked a little bit about how I approach jury selection, which, I mean, hopefully is at least minimally interesting. It's a much longer conversation with other lawyers because every lawyer has their own approach. And this is why I always am so curious when lawyers go to jury consultants, because you need to pick a jury that is going to listen to you and your witnesses. Or if you're the defense, you need to pick a jury that is going to listen to you, the attorney, and not automatically hate your client because they are sitting in the defense chair. But ultimately, you need someone who will listen with an open mind. And lawyers have very different opinions about what that looks like. I think jury consultants overthink that. It can matter in like high value civil litigation where there's actually time to go like look at a juror's social media accounts and get to know a juror a little bit more prior to it. But when you are doing day in and day out criminal prosecutions in a courthouse and you know the area, you generally kind of know the jurors that you're going to be dealing with. You kind of generally know the area where you are, if that makes sense. All right. Supplemental, that's not what I meant to do, that one. Supplemental briefing on docket number 1163 and 1165. And we're going to look at these rulings. That's why we're looking at the additional briefing. State's motion to pre-admit statements and email. State's motion to determine admissibility of jail calls and text messages. You guys. Rando from Iowa, talking about the dog. No, not the breed, the name. That's the dog's name. Yes, I think like Lord of the Rings, but yes, that's the dog's name. They filed an exhibit list of these exhibits, and we're going to talk about them. The parties have narrowed down the issues requiring the court's decision in connection with the state's motion to determine admissibility of statements and email and the state's motion to determine admissibility of jail calls and text messages. Regarding docket 1163, the state is providing the court with a revised redacted interview transcript on a flash drive and in a hard copy. The revised version contains 6 freestanding statements for which the state is requesting individual admissibility determinations. The revised version supersedes docket 1159 and the redacted interview transcript that the state previously provided to the court. The state understands the defense's unresolved objections to the revised version to request unredacting of page 1 through 7. I'm not going to read all the numbers. I am going to read page 125, line 6 through 16, except for, and I punched her. So what is this interview about? Well, I imagine this interview is after Eric Richins passed and after Kouri Richins got into a physically attacked her sister-in-law, who was the executor of the estate, when they got into a verbal argument over Eric Richins' safe that, to my best recollection, had in it money, weapons, and other possessions of value. And because Kouri Richins was not in charge of the estate, it is my recollection from very long ago that the sister-in-law was like, that's not yours. And Kouri Richins throat punched her sister-in-law. So in the interview, they are going to allow for redaction of the "and I punched her" bit. I imagine that's not going to come in at trial. That is a detail that came up at the bond hearing because it's appropriate at bond. It's not appropriate at trial, so I don't think we'll hear about that at trial. The state is providing the court with revised redacted jail calls and text messages. The revision supersedes, and then the state is saying what they want in. We don't have all these exhibits. They're sealed, so we'll see at trial, but there are things that will be redacted. The defense did not provide the state with any objections to exhibits 2-95 and 2-95T and 2-110. It's unclear to the state whether this omission was deliberate. The state has provided the defense with revised versions of the interview transcript and jail calls and text messages via box. All right. So they have narrowed down the objections. They have narrowed down what is being objected to. You see some of these objections based on Crawford and hearsay and, rules of evidence, 401, 402, 403. We're going to go to the judge's ruling. We're not going to go over all of that. But we also have an exhibit that indicates what's been provided, just so we have a little bit of a visual, which is helpful to all of us, of what the state is seeking to introduce, and a little bit of a preview, if you will, of what we are going to see at trial. So this is the exhibitees list regarding that motion. The descriptions, and I appreciate that they put that these are the descriptions from the party. They put plaintiff here because state of Utah, state versus defendant. They put plaintiff. So these are the state's descriptions of what the thing is. Search warrant, log of the call. These are all things from the night of. Transcripts of videos. I imagine these would all be related to the night that there was a rollout for Eric Richins. A whole bunch of search warrants. Emails from defendant's college transcripts, defendant's master's degree transcript. Why? Tell me why. Also, when did she get a master's degree? Search warrants, email regarding timestamp on jail calls, call with Lisa. This is mom. Call with mom. 1, 2, 3, 4, 5, 6 calls on September 11th. Transcript of call. Call with mom September 12th. Transcript of call. Call with Ronnie, brother, September 12th. Call with Lisa, September 12th. Call with Lisa, September 12th. Transcript of call. Call with Lisa. Call with Lisa. Call with Lisa. Call with Lisa. These are calls with mom. Wait, how many calls are there on the 12th? Calls with mom on the 12th. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, because there's a video called 14 Calls with Mom. 14 Calls with Mom on September 12th. Fuck, what's the date on the... Hold on. What's the date on the Walk the Dog letter? Is there a date on the Walk the Dog letter? Emily, are we pulling up the Walk the Dog letter? Yeah, Sidequest. Sidequest! Let's all go! I don't know if there's a date. I might have to go look at the docket to see what date this was admitted. Yeah, let me go look at the date real quick. This would have been right around the beginning of September. Hold on. I have a note about this somewhere. This is docket 214, everybody. Just in case you're curious, this is the
docket 214, but every law nerd on the internet calls it the Walk the Dog letter.
Yeah. Law nerds. Yeah. When we talk about the fact that people do watch the coverage, I mean, it's true. Every law nerd calls it. I just don't think that it is a turn of phrase that everybody uses just willy-nilly and part of their common vernacular. It's not just everyone on the internet. The Walk the Dog letter was filed in court on September 15th. Hold on for one more day. Law nerds, there was a motion filed with this for no contact order. Join me on the Sidequest. Here's where my brain's at, and this is the question I want to answer. Were all those calls on the 12th about this? Because this wasn't filed until a few days later, on the 15th, but it also had to be taken out of her jail cell. So they had to know it was happening. They had to go search the cell. They had to give it to the DAs. They had to file a motion. Is that what they were? Is that why there's so many calls on the 12th? That's what I want to know. So we're taking a look now. Sidequest. Just Sidequest. We're Sidequest. Sidequest on the Walk the Dog letter real quick. Sidequest. We're going to take a look as we jump ship onto trying to figure out why so many calls were happening on the 12th. This is the motion for no contact order that the state filed in connection with the Walk the Dog letter. I'm curious if this motion delineates the timing of those phone calls. And I saw a couple of you in the chat, including Terry M. 9973. How long is this trial supposed to take? It's set for a little over 4 weeks. Pursuant to policy on September 14th, Summit County Sheriff's deputies searched the cell block where the defendant is housed, including the defendant's specific cell. The search revealed a 6-page handwritten letter. The letter instructs Lisa Darden to induce the defendant's brother, Ronald Darden, who is Lisa Darden's son, to testify falsely in this matter. The letter claims the defense counsel wants to link Eric Richins, the victim in this case, to getting drugs and pills from Mexico to the fentanyl that caused his death. No such link exists. So they searched on the 14th. So, let's see. The state is investigating. It is currently unclear to the state whether the defendant passed this exact letter or its contents to Lisa Darden or anyone else. Significantly, on the morning of September 13th, on a video conference with Lisa Darden, the defendant held up yet another letter for her mother to read silently to herself. That letter was not found inside the defendant's cell. There is a strong inference that the September 13th letter was destroyed or flushed. The state's investigation in this matter is ongoing. I cannot tell you. Emily, you're going to regret everything you're about to say. Probably. I did in the Adelson case. I want to hear all of these calls. I said it in the Adelson case. In the Adelson case, I said, I want to hear all of the wiretaps. And then we got like 10 minutes into the wiretaps and I went, oh my God. Do we have to listen to this, bro, for another 2 days? Shit. I want to hear all of these. Because if this letter is recovered on the 13th, what are Kouri and her mom talking about for 11 calls on the 12th? Because I bet it's about this. And then how many calls did they have after this was discovered? Because this all got filed in court on the 15th. How many calls do you think they had on the 15th when this hit the docket? Because I bet you the calls on the 15th start with this motherfucking attorney. I bet you that those jail calls from the day after this hits the docket is nothing but them shit talking the prosecution. Look at how many calls this is. So many calls on the 12th. And then we get into calls on the 13th. Calls with mom, calls with Ronnie. I don't know what calls with DJ Kouri is. Is that her alter ego, like DJ Meredith Marks? Is this a Utah thing? Why are we all DJing? No, Emily Dorinda's also DJing. Why is everybody a DJ all of a sudden? I mean, I put together a mean mixtape. My whole life changed when you could burn a CD, but I need to know who DJ Kouri is. Is this the alter ego? I need to know. Look at, here's the search. So on the 13th, we've got a couple calls on the 13th. Then we've got the pod search video. Then we've got video jail calls on the 14th. Then we've got another pod search on the 14th. More video of pod search, another video call, more videos of the pod search, because they have to show the jury where they found the letter from. Videos and photos of the LSAT prep book, right? Because Kouri's going to be a lawyer. Calls with mom on the 14th. Call with DJ. I don't know if DJ is a person, like if it's a call with DJ and Kouri. I'm going to be interested when we get to trial to solve this. Calls with Lisa. Calls with brother. These are all calls on the 14th. And then we get to the 15th. We're on line 99, by the way. We're on line 99. These are the calls from the 15th. The calls from the 15th, which is when the walk the dog letter hits the docket, are from line 99 to line 105. Those are the calls that they are seeking to admit. It's actually less than I thought. I wonder if there are more calls that just have no evidentiary value or she's just complaining. Probably. That's pure speculation on my part. I'm just being snarky. All right. And then we've got calls on the 15th, 16th. A lot of calls on the 16th, calls on the 17th. It also could be that there were three-way calls there that weren't picked up because if inmates, and I would not say if an inmate would do this or not, but if, it's known to happen, if inmates call their lawyers can also have three-way calls. The lawyer lines aren't recorded. And so if it's like, hey, lawyer, I need to talk to you and mother, that is not an attorney-client privilege call, but it is also not a recorded jail call. So if the three of you need to have a conversation, there are rules about this. I'm not saying it doesn't happen. All right, more calls. Daily Mail exclusive from, well, around September 19th. I mean, what the fuck is that? This is why we had space for today to get ready for trial and Sidequest. Let's see. What year are these? These are 2023. Mom gave an interview. Mom gave an interview. Mom gave an interview. For those of you just coming in, Jules in the chat said, when does trial start? Monday. It starts on Monday. All right. I hate how many ads there are immediately. All right, it doesn't matter. Exclusive. Accused Moscow Mule murderer. Oh, y'all clocked this in the chat. I hate these titles. It's just disrespectful. I hate it. Exclusive. Accused Moscow Mule murderer Kouri Richins. We're going to call it Utah versus Kouri Richins. Kouri Richins' mother repeats narrative from daughter's prison letter claiming son-in-law Eric overdosed on fentanyl. Speaking to dailymail.com, Lisa Darden told us she believed her late son-in-law Eric Richins had bought fentanyl-laced drugs and simply overdosed last year. This is about the walk the dog letter. I have not seen an overdose where the thing, indicia, tools of the overdose are not near the person who accidentally overdosed. I've just not seen that. I've not seen someone accidentally overdose and get up and take their cup to the sink and wash it. Yeah, I haven't seen those facts happen. I've not seen an overdose where somebody overdoses on whatever and it is not in the near vicinity to where they are. I've just never seen that, because generally when people accidentally overdose, they have just it's not there. So you can tell with staged overdoses, or when you have something like where somebody has administered the thing that they overdose on, those get cleaned up, but someone else is involved in those, right? So with that, we are, it's just my thoughts on that. Her comments mirror, it's so funny. Who was searching Supernote at my house lately that wasn't me? I mean, it was me. Emily, do you need another Supernote? No, but the ads are distracting me. I bought a new pen recently for trial. Yeah, I did do that. Okay. Potato. Her comments mirror the narrative daughter Kouri Richins spelled out for her in a 6-page letter found hidden in her cell when she suffered a seizure last week. That's news to me. I know that she had been taken to the hospital. I didn't know exactly what that was because it's all been sealed because it's medical. They go on to say that Darden proceeded to bash her daughter's dead husband, calling him controlling, sometimes violent man who cheated on his wife. I've never seen this article before. Didn't we see Kouri's attorneys arguing this? Didn't we just see that? The mother of accused Moscow Mule. Can we just stop? The mother of accused Moscow Mule murderess. I hate it. Kouri Richins repeated the same narrative that her daughter had scripted in a letter found in her prison cell as she spoke for the first time exclusively with Daily Mail. Lisa Darden told us she believed her late son-in-law Eric Richins had bought fentanyl-laced drugs and simply overdosed. They tested them all. That is not an avenue to defense. Just as Kouri had spelled out her instructions in her jailhouse note, I don't think the Daily Mail necessarily believes them all the way. And she repeated Kouri's line that her husband would buy drugs abroad and ship them or slip them in her luggage without her knowledge. Darden, 64, spoke exclusively with Daily Mail on Friday. I feel like the Daily Mail doesn't even believe you on that. Darden, 64, spoke exclusively with Daily Mail on Friday after steadfastly refusing media requests for interviews since her daughter's arrest. Now it turns out virtually everything she told us mirrored the instructions laid out in a 6-page letter that prison authorities found in Kouri's cell after she was sent to the hospital following a seizure behind bars. I would imagine that they would probably redact that out unless it comes up. If Kouri testifies, this might come up. Photos of Kouri and mom, photo of Kouri and Eric. Richins, 34, was arrested. We heard that. Is there nothing else from the mother? All right, let's see. Eric died in March last year, and following his death, Kouri wrote a children's book on dealing with grief. Good Lord. Now wallowing in the Summit County Jail, she fell ill on Thursday after taking prison-administered medication, allegedly for the 6th time since her arrest. It sounds like y'all might need to change the medication. While she was in the hospital, guards searched her cell and found a copy of the bombshell letter Kouri had written to her mom, instructing her to fan conspiracy theories that Eric had a drug problem and overdosed. In the letter, Kouri asked her to get her brother Ronnie to concoct a story. It sounds like Daily Mail just doesn't believe her at all. To concoct a story that Eric, a year before his death, secretly told him that he'd get pain pills and fentanyl from a ranch in Mexico. Kouri wrote that she would back him up and say that Eric, 39, later told her about this conversation with Ronnie. That's hearsay on hearsay on hearsay. Clearly, the hearsay rule, hearsay's not really in the LSAT book is the problem. Yeah. She wrote that she'd also say that her husband asked if their caretaker, a drug dealer, okay, I think that's a bit strong. Let's go with a go-between named CL could hook him up with some more. For those of you new to this case, you're going to hear a lot more about CL. Yes, they will call CL by her name when she testifies. That's going to be an interesting day in court because the prosecution has put forth evidence so far that when Eric Richins didn't die on Valentine's Day, Kouri Richins went back to CL and said, I'm going to need some stronger shit. In her hour-long interview with the Daily Mail, Darden repeated the overdose narrative. Quote, I think Eric bought some pills off the street and they were laced and he didn't know it. She then proceeded to bash her daughter's dead husband, calling him controlling, sometimes violent, sometimes calling him a controlling, sometimes violent man who cheated on his wife and once punched her in the face after she confronted his mistress. Says the woman who throat punched her sister-in-law and was having an affair. Is it true or is it deflection? Unfortunately, Eric is not here to tell us. But we've got her text messages. Some of you have asked, how does the Daily Mail have this letter? It was filed on the docket, and you can see the filing stamp. So they grabbed it off the docket. I grabbed it off the docket. It obtained exclusively by EDB from the docket, the same way it was obtained exclusively from the Daily Mail. Every time they say these court dockets, especially when they're stamped, are obtained exclusively, they're from the public docket. They just went and got them. It's not exclusive. They just got it. All right. For an hour interview, they have like 3 quotes from mom. Where's the rest of it? They go on to say, and despite Kouri's initial claim that Eric didn't take drugs other than the occasional pot gummy, that I believe, because they found those in the house and tested them. You know what they didn't find in the house? Fentanyl. They didn't find fentanyl. There were no, Northwest asked, were there pill fragments in his stomach? There were no pill fragments in his stomach. And Kouri told the police that she made them drinks that evening to celebrate. Despite Kouri's initial claim that Eric didn't take drugs other than the occasional pot gummy, the mom said he ate gummies daily. I mean, I do too, but they're like magnesium. And brought marijuana and possibly other drugs home from international trips. I mean, you could just like drive to Vegas or California. You don't have to cross a border to get weed. I mean, what year are we living in? Also, can we all just leave the weed alone? For all of you asking, Amanda in the chat said his mom said that. No, this is the defendant's mom. This is the defendant's mom. But yes, I love a gummy vitamin because I'm 7. Can we just leave weed alone for fuck's sake? The only problems. I worked in a very busy DA's office. Can I tell you the problems I saw with weed? Can I tell you what the issues I saw with weed were? The biggest problem I saw with weed as a criminal prosecutor was that dispensaries or dealers couldn't put their money into banks because of the disparance in laws between the federal laws and the state laws. So there was a lot of difficulty with putting money into bank accounts that are FDIC insured and worrying that that money was going to get yoinked by the federal government. So the issue I saw with weed were robberies because there were large amounts of cash and robberies of plants. Those are the biggest issues I saw with weed. Other people coming to steal the money or literally the weed. That was the problem. Nothing else. I did not see people going on rampages of weed-induced giggling, snacking, whatever. It was always just the theft crimes. That's it. Lot more problems with drunk driving. Lot more problems with, opiates. Lot more problem with opiates. But with the weed, that they couldn't put it into banks. Oh, if only that problem could be easily solved. For fuck's sake. All right. Continuing on. Meth is a whole different story. We're not even going to talk about the horrors. Weed, just the Lauren, I'm not surprised by this. That our DUIs with pot have skyrocketed. I'm not surprised by this, but by the time I was transitioning out of the DA's office, we were, also California, but we were not in a state where weed had never been around and all of a sudden it was legal and people didn't know what to do. But Hannah said, work in an ER, can confirm meth is the worst. Fucking the worst. Corvus said, as a medical cannabis patient, thank you, Emily. I mean, you're welcome. If you guys don't watch Amy Van Dyken, do you guys watch Amy Van Dyken? If you don't watch Amy Van Dyken is the most Olympian to ever Olympian with all of her medals, but also has talked a ton about marijuana in the medical context. And after her accident, when she was paralyzed, the devastation of prescription medication and her transition into medical cannabis. And she shares so much about that journey and how much it helps with her nerve damage, nerve pain, phantom pain. It is her story to tell. She has a YouTube channel here. Follow her on social media. But she does a ton of work in advocacy, trying to help people understand that there are other options. So don't take my word for it. Listen to her. But this whole oh my God, it's a weed gummy. I just can't. Fucking miss me. I just don't have any energy for it. I really don't. If it's not for you, fine. If it is for you, fine. Chad is saying that if Ryan Hall's talking about you, don't worry. The replay should be up on this at some point. Go listen to Ryan Hall talk about you. Okay. Finishing up this. Emily, you're a streamer that said go watch another streamer. If Ryan Hall's talking about you, it's more important. Ryan Hall shouldn't be talking about me today. I don't like it. Side note, I love watching Ryan Hall stream. I think he is absolutely great at what he does and does a tremendous amount of help. But the wildest thing to me is looking at his chat, because not law nerds. He gets a lot of people scooting by. For those of you that are like, who's Ryan Hall? You don't live in a place with extreme weather, and that's lovely for you. He is the internet's weatherman. He covers severe weather events, etc. But There are always people in the chat, because not a law nerd chat, but there are always people in the chat that are like, what about this? What about where I live? And they put exactly where they live. What about where I live? And I'm like, you all don't want Ryan Hall talking about you. If he's talking about you, you should probably have a charged phone and take it with you into shelter. You do not want Ryan Hall talking about where you live. If he's not talking about where you live, it's not the most severe weather that's going on, and that's fine. Everybody's like, what about me? No. Also, he says daggum unironically. I know. As a very cursy Californian, I absolutely love it. Absolutely love it. All right. Back to demonizing the victim, I suppose, is what they're doing here. I hate all of it, but I was very curious what this article said, because this is what we're going to see from the defense. Is anyone shocked? No. Appalled? You're welcome to be appalled. Shocked? This is what we've heard the defense saying too. So even though I hate it here, we're going to see this at trial. Might as well have a heads up. A lot of you are saying you are Kentuckians. Always Clarks. Lori, it is always Clarksville. We were driving through Clarksville. We drive through Clarksville a lot when we're doing stuff. It was always Clarksville. But it was funny because I was taking Travis. Was it when we were going to I don't remember which trip we end up traveling north of us so often these days. But we were traveling, I think, to Evansville, and we kept seeing the signs for Paducah. And the only reason I know where the fuck Paducah is because Ryan Hall is almost always at some point talking about Paducah. And I was like, I actually know the areas around me a little bit more because of watching Ryan Hall's coverage. Also, Clarksville needs a Buc-ee's. But it was so funny because I'm like, I know where that is. Dr. B's like, what the fuck are you talking about? I'm like, it's Paducah. What do you mean you don't know? Ryan Hall talks about Paducah a lot. Paducah and Clarksville get talked about all the time. I was delighted. So I love that now when I am traversing Kentucky, Indiana, Missouri, wherever, I know the areas a little bit more because I watch Ryan Hall. I actually feel like I know the area better just from watching him, which makes me so happy. All right, continuing on before I digress and we just start talking about the geography of Tennessee and Kentucky to the exclusion of most of the chat that's going to be like, what are we talking about? Emily, you hate reading this article so much. I know. Despite Kouri's initial claim that Eric didn't take drugs other than the occasional pot gummy, the mom said, this is Kouri's mom, said he ate gummies daily and brought marijuana and possibly other drugs home from international trips. I know, quote, I know 2 occasions he bought in another country and put stuff in Kouri's bag and didn't tell her there were drugs in her bag until they were up in the air, says Kouri's mother. She said Eric, whom she described as a hypochondriac. Okay. That's not coming in at trial. Even stopped a few times to ask her for prescription pain pills after she had surgery. I had several surgeries, so he thought I would have oxy. How do you know that? He'd come by and say, Lisa, have you got anything for pain? Got anything for pain? Anyone in the chat who has dealt with someone who has a chronic pain issue or reliance on prescription meds, have you ever had that conversation? Ever? Fucking ever? It's just not believable. That conversation is not believable. Here's some Advil, buddy. If people are looking to take your prescription, what they're not doing is walking into your house saying you got anything for pain. If they are walking into your house looking for a fucking Advil, then that might be the sentence. If they are looking for pain pills, they're not asking you for them. They're going to ask if they can use your bathroom. And then you're never going to know until you're like, huh, it seems like some of this is gone. Like this is just not believable. Either way, unless he is coming in asking for an Advil. She added cryptically, oh, Jesus. He'd asked these workers, got anything for pain? It's going to be real interesting if she testifies. Oh my God, imagine my surprise. And the chat said, did she respond, quote, no, you fool? 10 out of fucking 10. 10 out of fucking 10, 10 out of 10. She's on the witness list. Quote, do I know that he went out on the street? She added suggestively. Dude, the Daily Mail has smoke for this woman. I know what people have told me. So hearsay on hearsay. Darden's comments come as she struggled to understand exactly why her daughter had a seizure, an incident her mom described as absolutely terrifying. Yeah, I have questions too, but a spokesman for Eric's family told Daily Mail that there was no truth to any of what Darden said. Quote, but I wish she was a little bit more sensitive to his children when she publicly slanders their father. Oh, look, a reasonable statement to the Daily Mail. Can you imagine how frustrating this would be? These things live forever. Quote, too bad we can't request a polygraph test, he added. Kouri's mother blamed the jail for giving Kouri the wrong medication, said she was initially kept in the dark about the cell search. Why would the jail call the defendant's mommy and tell her that the jail cell was searched? Ma'am, did you do your kids' homework when they were in school? I'm just curious. Were you calling her boss and being like, hey, Kouri's got a headache. She's going to need a day off. Like, why would the jail loop you in? You don't have any rights as to your adult child in this circumstance. Kouri's mom says she was initially kept in the dark about the cell search, which led prosecutors to accuse the daughter of witness tampering and to ask the judge to bar Kouri from having any further contact with her mother or brother, who are both slated to be witnesses to the trial. Get the Lawnerd app. You're going to want to know when they take the stand. On Friday, Kouri's mom was still in communication with daughter, relieved to report that her daughter was feeling better, though awaiting blood test results to learn exactly what happened. I'm curious if anything came of that. There are some additional photos. Daily Mail previously reported that Eric Richins, pictured with Kouri, her brother Ronnie, and her mother, had even left a letter to the family instructing them to check out Kouri in the event that something happened to him. What? That's an interesting tidbit of information. I wonder if that's around the same time he changed all of his wills and trusts. Because that is new. That's interesting. I guess we'll see what comes of that at trial. We do know that he changed his will and his trust. We do know that at some point he discovered the monetary fuckery that was happening. Let's see. Contacted after the news of the letter broke, Kouri's mom on Monday refused to comment. Quote, sorry, I'm not giving no comments to no one, she texted dailymail.com. How did they get people's numbers? Y'all, today's a good day to remind you that even though not a sponsor today, they are a sponsor of the channel, that Incogni can help get your number off the internet. Like, how does the Daily Mail have this woman's number to text her? She also rejected a visit, saying that she would be, quote, gone all day. But on Friday, she was anxious to try and reverse the public narrative of her daughter as a cold, calculated murderer. This article has all of the smoke. Prosecutors say Kouri A Mormon raising 3 sons with Eric outside Salt Lake City. Do we have to? Like, just because somebody's in Utah does not mean we need to talk about their religion. It has nothing to do with this. Unless it's Secret Lives of Mormon Wives, can we just not? Because she was trying, I mean, I know, y'all, she was trying to flame Eric for not going to church. And she's saying that her sister-in-laws are jealous of her and she goes to church more than they go to church. But can we not? Just can we not? All right. I'm skipping the rest of that because there aren't even charges, and there's no charges that Kouri was moonlighting as a drug dealer. There are literally no charges regarding that at all. Josie asked, is it entirely irrelevant though? To this case, I think that it is. I mean, I think anyone can look at Kouri's behavior and be like, I mean, I see you. But this is a domestic violence case at its heart. At its heart, this is a spouse murdering another spouse. That's what it is. So she's accusing Eric of cheating. We also know that she was cheating. We have no information if Eric was cheating. We're going to be talking about how they got drugs and the rest of it. The prosecutors and the defense attorneys are going to be mindful of the attitudes, beliefs, and sentiment of their jurors. So for picking a jury, it might matter. For us, it doesn't matter that much. This is about a woman who seemingly is accused of killing her husband for financial gain to escape a marriage in the midst of also having an affair. So knowing how your jurors might see things matters. It might inform why the defense wants to try to throw mud at the victim, though we see that in almost every case, regardless of where it is. It's why people don't always want to go through a criminal case. People don't always want to report crimes because they don't want to do it. So I don't think it's going to come up other than the way that the prosecutors and defense talk about the case with the jurors. Does that make sense? But in the context of this article, I think it's just to continue to hook people in to, or try to find more salaciousness. But I do want to see what the mom is going to say. They go to say that Kouri allegedly poisoned her husband in March 2022, then waged a legal battle within weeks of his death in a bid to secure an estate valued in excess of $3.6 million. That is still ongoing. That's true. She later published a picture book to help children cope with losing a loved one and put his picture on the front of it, and that is part of those lawsuits. Quote, "This case is so bizarre, you couldn't write a story this good." Kouri's mother told the Daily Mail, quote, "This case is so bizarre, you couldn't write a story this good." We instituted Code 404 fucking yesterday. It was yesterday. How am I back to 404ing? Ew. Kouri's mother tells the Daily Mail, "This case is so bizarre, you couldn't write a story this good." Standing in the doorway of her home in a desolate Utah mountain town, quote, "I've lived it." Ma'am, we are doing our best to keep the chat from speculating about you. Could you help us all out a little bit? Because that's not helping. We really try. We really try. We talk about not speculating. We don't talk about things that are going on outside of court all the time. Ma'am, you're really going to make it hard, can you not? I've lived it. We'll get back to that another day. After this trial, we'll get back to that. It's in the financial case. We'll get there a different day. Today is not the day, Emily. Keep moving. We're on a side quest to a side quest to another side quest. And we still have documents to go through and there's hockey to watch. I get it. No spoilers. They make me cry. Kouri's mom said that she's convinced of her daughter's innocence and proceeded to unload on her deceased son-in-law as well as the caretaker/drug dealer who was expected to be a star witness in the future trial. Kouri's mother said that Eric, who came from a prominent Mormon family, and is it Camas, would cheat on his wife and left her with a black eye after she confronted his former mistress. No. Why are we putting people's names in this? No. I'm skipping it. Also, I have so many questions about all of these allegations. This isn't going to come up in trial. The defense is tried. This isn't going to come up in trial. Also, if Kouri was walking around with a black eye, I would guess that we would need to also inquire if it could come from Beauty Lab and Laser. I am just saying there are numerous ways that one can end up with a black eye, and some of them involve cosmetics. Just a point of curiosity. I was told that Amica cream would help it go away faster. Not fast enough. All right. Continuing on with this depressing article, it goes on to say that Kouri's mom said that Kouri grew suspicious when her husband's phone rang at home. She picked it up, and the woman on the other end instantly hung up. Excuse me? How do you know it was a woman on the other end if they instantly hung up? I have questions. Zilly in the chat said it was Jen Shaw. Jen Shaw's like, look, man, I'm just trying to finish out my prison sentence. Can you leave me be? Can you leave me be? Kouri quizzed her husband. He confessed to the affair. This is all according to Kouri's mother. Kouri then phoned the alleged mistress the next day, shouting at her and demanding she leave her husband alone, the mom said. Eric responded angrily, and this wasn't the first time. He's pushed her. It says I'm just going to try to read this directly as it's written. The quote is, he's push her, he'd punch her. Again, there is no evidence of any of this. Approached by dailymail.com, the alleged mistress acknowledged the call and denied the affair. Quote, she asked me and I said no, and that was it. The alleged mistress of the victim told the Daily Mail. None of this is going to come in. I don't know why they're even saying my name now. I haven't talked to Eric in over 4 years. There was nothing. He was my friend through work. That's it. So if someone he worked with, I could assume that their name might be saved under their own name in their cell phone. If it's a mistress, probably not saved under their name in the cell phone, and that's how they knew who hung up. If you heard Kouri answering the phone, would you hang up immediately? I wonder what their prior interactions were like. There's more context to this that we do not have. But they sure got out in the media right after this to try to change the narrative, didn't they? This is right after the Walk the Dog letter came out. Why are you talking to the media now? Oh, because you're talking about Kouri and not the victim. All right. We're not dragging this poor woman's name into all of this. They go on to say that Eric was an avid outdoorman and hunter, but Kouri's mother said he would take it to the extreme, sharing a time he alleged... No. Oh, okay. Chat, I will link this article if you want to read it from the Daily Mail. I'm not reading the rest of this. This has spiraled into a level of dumb fuckery that doesn't really even need our energy. Why did I think it would be different? I don't know, but it has spiraled. All right. I was curious what this article would have in it since it's on the witness list. But it is just absolute, unfounded, self-serving bullshit. If A, not relevant to trial. B, how did we end up here? For all of you that popped in and are like, how did we end up here? Because we were going through the evidence list. And the Daily Mail exclusive article is listed on the list. That's why we went to look at it. Sometimes the side quests are good decisions. Sometimes we just we need to pull the car over, turn it around. Whoop, we're done. Whoop, whoop, whoop. Backing up. However, this could be used as impeachment of potentially Kouri's mother, Kouri, etc. I'm not surprised this is one of the things that they're having the court look at, because it could be argued that this tends to show that they are building a story, and it tends to show that Kouri's mom is aware of the letter. Was Kouri's mom aware of the walk the dog letter before it was in the media or after? These are questions that will come up. Continuing on from our side quest, apologies, chat, for immediately yeeting the side quest back into oblivion. We've now got additional calls, text messages, transcripts of calls, emails, reports, warrants, seized property with over 133. No, that's not linear. It looks like almost 160 items of evidence on this list of calls and texts that the court is considering. To get us all the way back to Emily, what is the court considering? Admissibility of the walk the dog letter, jail calls, text messages, etc. Why does it matter? Well, the defense attorney has said that the defendant is going to testify. That's part of why it matters. And the mom's on the witness list and the brother's on the witness list. And if they try to come in and give the story that Kouri was telling them to take vague notes, so you remember, yeah, it's going to come up that she was in the jail calls telling them what to say. It's 100% going to come up. So that's why it is listed there. Does that mean it will come in at trial? That does not necessarily mean it will come in at trial. It means it could. And everyone's aware of it. Right? Okay. Let's get to the next in order as we go through a very chatty day of looking at documents. I have to get back. I was in docket 214 because that's where we needed to be today.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
I now need to get us back to the docket numbers that we were on, which was docket number 1569. Docket 1569, and we are jumping to docket 1573. Oh, wait, no, that's the Limine ruling. That's not the one I want. That's not the one I want. There, I want to look for the ruling on what we were just talking about first. Oh, it might be in the Preemptories. Okay, let's do that one. We're going to go take a look at the rulings on the Preemptories, which should include the ruling on the motion to pre-admit. If it doesn't, we'll go find it. So let's get to some of the judges' rulings, shall we? I know that we have wandered far. So just to coalesce where we're at, the prosecution is asking the court to rule on the walk the dog letter, journal, interviews of defendant, jail calls of defendant. And the thing is that if the defendant doesn't testify, if the mom doesn't testify, if the brother doesn't testify, the things that were said on jail calls by mother or brother can be hearsay. They can be admitted for a non-hearsay purpose, but they could be hearsay. Kouri's statements are party opponent statements. Those can come in. However, there can be things in those statements that are more prejudicial than probative, so they don't come in for that reason. So there are evidentiary rulings on all of this because there are levels to hearsay. You know, there are layers, like an ogre. You have, is it authentic? First. Once it's authentic, do the things within it come in? Are they hearsay? Is there an exception? Who's offering it, etc.? So that is a large part of what motions in limine handle is, Your Honor, do we really have to have a fight over whether or not this is a hearsay statement when we seek to admit the thing, because we can all see what the objections are going to be and argue it beforehand? Of course, most of those rulings are either a yes, but, or a no, unless. Like, no, this doesn't come in unless the door gets open. Yes, this comes in, but it can be limited, etc. Make sense? Wonderful. Ruling regarding motions in limine argued January 8th. We saw some of the motion in limine argument. We got yeeted, like, no, you can't sit with us, from some of those arguments in a sealed hearing. Before the parties' motions in limine, which were argued, or before the court of the motions in limine, which were argued and decided by the court during a hearing on January 8th, this court incorporates the substance of the hearing into the written ruling and order. Remember, the court did ask for additional briefing on some of the things, which is what we are seeing now. The state's motion to determine admissibility of the walk the dog letter.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
The state seeks an order determining the admissibility of the first 3 pages of the redacted document found in defendant's jail cell, referred to as the walk the dog letter. Every law nerd on the internet knows. This is the walk the dog letter. Emily, how much do you love your new software that you can just flip between documents so easily? There are not words to express how happy I am. Walk the dog, but take vague notes so you remember. Do you remember? I mean, this letter did happen in September, at least. Emily, why only the first 3 pages? Well, the additional pages are just shit talking. They don't really have evidentiary value. They have value for us, but they don't have evidentiary value for trial. Because really, they're just shit talking. Could some of these become relevant later? Maybe. When she's talking about the best way to get at her sister-in-laws is by leaking photos of the sister-in-law's kids to the media. Those things could come up later. But it's not what they're seeking to admit. They're seeking to admit the first 3 pages, which are the story of what all went down. The state seeks an order determining the admissibility of the first 3 pages of a redacted document found in defendant's cell. The defendant opposes the motion, arguing the admissibility of the letter is unfairly prejudicial because it implies that the defendant was attempting to tamper with a witness. Girl. She's telling them what to say to her lawyer for her defense. Coaching a witness? I mean, if the witness wants to be tampered with, is it really tampering? Assisting the witness in their memory? What do we want to call it? She's telling them a story. The court finds that the redacted first 3 pages of the letter are relevant under Rule 402, and the probative value of defendant's internal thought process about the alleged crimes charged in the case. In the letter, defendant crafts an In the letter, the defendant crafts an exculpatory narrative about the death of Kouri Richins. The statements in the letter can be fairly compared to other statements defendant made about the death of her husband. The state may fairly argue that the letter is probative of defendant's consciousness of guilt. I mean, that was said much more eloquently than I've said anything today. So 10 out of 10, Your Honor. Thank you. However, The court finds that the probative value of any implication or argument by the state that by writing the letter, defendant was preparing to, attempting to, or actually tampering with a witness is substantially outweighed by the danger of unfair prejudice. The letter was found in defendant's cell. It was not sent to another person, and any implication that defendant was using the letter for unlawful purposes is unfairly misleading and prejudicial. Oh, look, Your Honor, how reasonable. However, I imagine that if defendant's mother comes in and testifies to basically what's in the walk the dog letter, at that time, the prosecution will say, "Excuse me, Your Honor, can we get back to the walk the dog letter? Because I'm gonna need to ask Mom about this." And then Mom's gonna go, "I know nothing about that." And then we're gonna go, "Sure. Okay." And then the mom's gonna say, no, it's because it's the truth. It's because it's the truth. It's in the letter because it's the truth. Well, then why does it need to be in the letter? If everybody knows it's the truth, why do you need to take notes? Like, it's not a passcode to your cell phone. Why do you need notes? Just asking. So the judge is like, yeah, you can use the letter. You can't imply that you can talk about this is what she thought, this is what she was saying, but you can't imply that she was trying to get everyone on side to tell a story. And then if they testify, it's going to be cross-examination. The first 3 pages of the walk the dog letter as redacted are admissible, subject to limitations in this ruling and subject to the state laying proper foundation, which is why we're going to see some of the where did the letter come from and who wrote it. Fair. State's motion to determine admissibility of Orange Notebook. We don't know what's in the Orange Notebook. The Orange Notebook was subject to numerous motions or part of the arguments in the motion to suppress. I think they went with inevitable discovery. There were issues around the Orange Notebook when we saw it discussed. We didn't know what was in it. We just saw that the Orange Notebook was discussed and that it purports to describe what happened to Eric Richins in the journal. The state requests an order that 5 pages found in an Orange Notebook that was seized by police on the day of defendant's arrest are admissible. The notebook contains what appear to be journal entries written by defendant on March 3rd and 4th, and they describe what defendant and Eric Richins were doing the night he died. The court determines that the statements made in the Orange Notebook, if written by defendant, are not hearsay and are probative of what happened the night of Eric Richins' death. The statements may be fairly compared to other statements defendant made. The state's motion is granted subject to the state laying proper foundation that the defendant wrote it. Fair. State's motion to admit defendant's notes. I don't even know what this is. The state seeks an order that a set of notes that were found in the defendant's kitchen cupboard on November 7th, 2024 are admissible. The notes were not found in April 2023 when the house was initially searched by law enforcement. The state argues that the content of the note or notes supports a reasonable inference that defendant wrote the notes after her interview with Detective O'Driscoll to help her remember the things that she told him. Oh, no. Girl, no. No. If it's the truth, do we need to write it down? I imagine the defense will argue, or because we know the defense was watching carefully what happened in the Karen Reed case. I imagine the defense will argue that due to stress, grief, and trauma, she wanted to write down what she told to law enforcement so that it didn't seem suspicious if her story changed because she was traumatized by this. I imagine we will see that argument when this comes in. Because it sounds like the state is arguing that you need to keep track of your lies, and so you're writing them down. And the defense is going to be like, no, just she's aware of the traumatic effect of what happened, so she's writing things down. It depends on what it says as to how convincing that will be. Defendant objects under Rule 403, arguing that because the notes have no context, they are confusing or misleading. Defendant's arguments that the notes are misleading go to the weight of the evidence and not the admissibility of the evidence. The state has provided a reasonable basis for a jury to find that the notes were written for the purpose the state alleges. Well, why are the notes in the cupboard and not just in all the journals? The state has provided a reasonable basis for the jury to find that the notes were written for the purpose the state alleges. The notes are relevant under Rule 402 and not hearsay under 801. In addition, the probative value of the notes is not substantially outweighed by the danger of unfair prejudice. I told you guys we have covered this case since the beginning, and there is still stuff we do not know. There will be more at trial that we do not know. And the state's going to argue consciousness of guilt. She's trying to keep her lies straight, right? She's walking through the spider webs. And she's got to figure out what story she told when. State's motion to pre-admit interview and email with O'Driscoll. The state seeks an order regarding the admissibility of 6 highlighted excerpts of a transcript of an interview with Detective O'Driscoll conducted with defendant in April 2023. A follow-up email drafted by defendant in April 2023. Defendant does not object to the admissibility of the interview excerpts so long as the jury is instructed that the law enforcement side of the interview may be considered only for the effect on the listener. It's hearsay. I mean, he's going to testify, I'm sure, so then it'll be testimony. And not for the truth of the statements made by law enforcement. Defendant does not object to admissibility of the follow-up email. The 6th portion of the interview and email are admissible and relevant. Great. It sounds like there's no fight under that. The defendant argues that under the rule of completeness, she may seek to have other portions of the transcript admitted at trial. Rule 106 allows the defendant to require the admission of portions of the transcript that in fairness ought to be considered at the same time as the portions admitted by the state. If defendant seeks to invoke the rule and admit other portions of the transcript to prevent misleading the jury, defendant shall file a surreply outlining their request. So if you want more to come in, you need to page in line. Tell us what's coming in so we can deal with it before trial, because we're not like unredacting the redactions while the jury's waiting. State's motion to admit jail calls and text messages. The court defers ruling on the state's motion until the parties meet and confer about possible redactions, and that's what we just saw. The court will rule on defendant's objections based on relevance and prejudice in subsequent order, or in a subsequent order. State's motion to exclude evidence that victim committed assault. We just saw some of this in that article. We heard some of this in the motion arguments that we saw. The state seeks to exclude evidence the defendant told. That's hearsay. The state seeks to exclude evidence that defendant told her father-in-law that Eric assaulted her because it's not relevant, unfairly prejudicial, improper character. The court says unless a material change of circumstances occurs at trial, defendant does not object to the state's motion. The state's motion is granted. Evidence that Eric Richins assaulted defendant, and evidence seems to be that Kouri told somebody, is excluded subject to a material change of circumstance. If Kouri testifies, that may change. State's motion to exclude evidence that victim abused drugs in high school. The state seeks to exclude evidence that Eric Richins used illicit drugs or abused prescription drugs in high school. The state argues that it's not relevant because it happened 2 decades before his death, unfairly prejudicial, improper character, propensity evidence, and hearsay. The parties disagree on the specific substance of the evidence and whether there is any non-hearsay avenue for admission. The court defers ruling on the state's motion until after the parties have an opportunity to voir dire, witness Kouri Richins, or provide other evidence outside the presence of the jury to determine whether there is a non-hearsay route to the admissibility of the proposed evidence. To prevent a mistrial. To prevent a mistrial, the parties are strongly cautioned, bold, underlined, against referencing to or referring to this evidence during opening statements. I bet you this judge would immediately grant a mistrial if somebody referred to it, because you can't unring the bell. I bet he would immediately grant a mistrial. Your Honor, I'm joking. Your Honor, have you been watching our Ron coverage? Yeah. I don't think these attorneys would wild out like that. But better safe than sorry. Remember, you have to give them a heads up that contempt is possible before you can contempt. That's why contempt doesn't get done a lot, because judges forget they have to give a heads up. Like, there's a lot of work judges have to do to contempt. They think about it with witnesses more than they think about it with lawyers. That's a strong warning from the judge. Defendant's motion in limine. Defendant's motion to exclude, evidence of a book written by defendant and her sons. There's new information in that heading. So I was trying to... This document's fighting with me. There's new information in that. Also, the book was ghostwritten. Defendant seeks to exclude evidence that defendant authored a book about death and grief approximately a year after Eric Richins' death. The state intends to argue that the defendant marketed the book and that her mother sent a copy of the book to investigators in an effort to convince them that the defendant did not cause her husband's death. The state intends to present a picture of the cover of the book, a screenshot of defendant's interview copy of the... She sent a copy of the book to investigators. What is happening? No, you didn't. Girl, no, you did. No, you did not. No, you did not. No, you did not. No, you did not. Emily, what book? Hold on. There actually is a picture of the book in here. We saw it. The book is no longer on Amazon. Also, hold on. Sorry, I'm scrolling this article real quick. Here's the cover. This looks like, this says ABC, but she did talk to KUTV as well. This is the cover of the book with Eric Richins with a halo and angel wings and a zip-up dad vest and a kid apparently playing soccer that says, "Are you with me?" Dad is cheering on the soccer. Sent the book to investigators. That's bold. The state intends to argue that defendant marketed the book and that her mother sent a copy of the book to investigators in an effort to convince them that the defendant did not cause her husband's death. The state intends to present a picture of the book cover, a screenshot of the interview. So they're arguing consciousness of guilt. The state's proposed, The state's proposed evidence is relevant under Rule 401 because it's probative of how defendant reacted to her husband's death. The probative value of this evidence is not substantially outweighed by the danger of unfair prejudice. Like, right, because she did it. She did that. She wrote the book. She did the interviews. She did those things. So even if it is prejudicial, it's not unduly prejudicial in this case, because these are things she did after the death of her husband. The parties may argue any reasonable inference based upon the evidence, including an inference the defendant wrote the book because she was grieving her husband's death and trying to help children who have experienced a similar loss. During a January 8th, 2026 hearing, defendant requested the content of the KUTV interview be admitted under Rule 106. I see what you're doing there, defense. Smart. I don't think that's going to work, but smart. Emily, what are you talking about? They want to admit an interview where I am guessing that Kouri is talking about her grief, how she felt, an interview that would probably humanize Kouri, and the defense gets a bite at the apple without Kouri having to testify and be cross-examined. You can't just picky-choosy. It's like, well, you can play the whole interview then. So they're arguing completeness and that they should play the whole thing. The state does not intend to offer statements from the interview. Rather, the state's motion is limited to a photograph and the fact that the defendant did an interview. Smart, because the state is just like, no, the fact that she was giving interviews is all we want. We don't need her self-serving statements in an interview about what a grieving widow she is and how hard it is. We don't want any of that. Because Rule 106 only applies to statements, Rule 106 does not support relief the defendant requests. If the state admits a statement from the interview, defense may re-raise the issue. Defendant's motion is denied. Respectfully denied. Defendant's motion to exclude a 2020 recording of a partial conversation between defendant and Eric Richins. What? What? In 2020, Eric Richins recorded a conversation he had with defendant that indicates he did not know that defendant took out a HELOC on his home until after she had taken it out. These are part of the forgery case for the home equity line of credit. The home was only in his name. He owned it prior to marriage. It was not community property. It was excluded in the prenup, etc. No, it might not have been explicitly excluded in the prenup. Asterisk. The partial recording has minimal probative value. Interesting. It shows distrust in the marriage and defendant's efforts to secure a source of credit. Other evidence, weightier and more temporally close to the time to Eric Richins' death, is available to the state to show defendant took out a home equity line of credit and had an affair. The minimal probative value of the recording is substantially outweighed by the danger of misleading the jury. So the court's keeping this out. If she testifies, though, I wonder, because if she testifies everything was good and gravy, this might come back up. He changed the will and the trusts and stuff, I believe, around this time in 2020. It was not super close to his death. I believe it was around this time. Let's see. The minimal probative value of the recording is substantially outweighed by the danger of misleading the jury, undue delay, and wasting time under Rule 403. The transcript of the recording is an amalgamation of 6 separate audio recordings. 6? 6 separate audio recordings. Substantial portions of the recording are inaudible and may lead the jury to inaccurately speculate about what was said. There is danger that some of the statements from both defendant and Eric Richins could be taken out of context. Moreover, there's limited probative value of the evidence, limited probative value, and that is substantially outweighed by the time it will take for the jury to listen to all 6 recordings and then compare each of those recordings to the non-certified transcript to determine what weight, if any, to give the evidence. For these reasons, defendant's motion is granted. Oh boy. Heather asked, do we know why he made those recordings? Was he going to use it in court? Was he going to take her to court? We do not know. However, this is close in time to when he was changing his will and had discovered, based on the financial case, that she was leveraging his assets. So it would not surprise me if this was in connection to those conversations with his lawyer. It would not surprise me if that was in preparation for that. So the financial stuff was in fact a brewing storm that caused him to change his will. That's not going to come in. But we know that he changed his will. We know that he talked to a divorce attorney. We know that some of this is going to come in more. I also imagine that how you would want to prepare for potentially fighting a divorce and custody battle in Utah as the husband is going to be different than how you would prepare in Utah as the wife. So that would not surprise me. But we might not know in this part of the case. Remember, there's also a there's also a financial fraud case that's separate from this case. However, if she testifies contrary to some of this, I imagine it will come back up then. Dawn asked, did he change the will before Valentine's Day or after? Well, before. It was around this time in 2020 that things were changed. Hold on. I don't have it in the notes I have pulled up. Give me 1 second, because I can, that's a loop I can close because it's in the estate case when this was changed. I have the date on it. The attempted murder is charged in Valentine's Day 2022. The will and trust were changed and established. I'm just looking at the will real quick. Let's see. What is the date of the signing? Because they would have had a conversation before the signing. I'm just looking at the date that this was signed, which gives us a range of time. This was signed November 3rd, 2020. So there would have been conversations before that. It would have taken time to get typed up. There would have been another conversation about coming in and signing it. It was wet ink signed with a notary. It was sworn and signed November 3rd, 2020. So yeah, right around the time of these recordings in 2020. So within the year of the recordings, we don't know exactly when those recordings were. That is going to come up in the estate case. I'm sure that's going to come up in the financial case more. So we will see. All right. So that is kept out at this point. Again, if defendant testifies contrary to that, the prosecution will ask that it be allowed at that point. Motion to exclude the HELOC loan on Eric's residence. All right. Defendant moves to exclude the evidence that she took out a home equity line of credit on Eric Richins' home in 2018 because Eric Richins knew about the HELOC before his death. Defendant argues the evidence is irrelevant and prejudicial. Evidence that the defendant obtained a HELOC with a credit limit of $250,000 on Eric's home is relevant to the defendant's financial circumstances leading up to the death of Eric Richins. Evidence that she withdrew $264,000 on the HELOC. She just pulled all the equity out then. Is irrelevant to whether she had exhausted sources of credit available prior to his death. Yeah, she didn't have the Murdaugh treatment where he was just withdrawing everything and they were just like, it's fine. Yeah, she didn't have the Murdaugh treatment. The evidence is probative of defendant's financial condition at the time of Eric's death, relevant to defendant's potential motive to kill her husband for pecuniary gain. Remember, she did not know that the will and trust had changed. We learned that in the bond hearing. We're going to hear about it in the trial. Through her own words, Scotty didn't know. Scotty didn't know. The probative value of this evidence is not substantially outweighed by the danger of unfair prejudice. Denied. Motion to exclude video and photos of Eric Richins' body. Those are going to be sealed, but they have to come in. Defendant seeks to exclude a video that depicts, among other things, defendant while EMTs perform life-saving measures on Eric Richins the night of his death. A picture showing lividity on his body when he was found. Oh, that's relevant. All relevant photographs, regardless of their alleged quote-unquote gruesomeness, are subject to the balancing test set out in 403. You cannot say that because what happened to the victim was so horrific, the jury can't see it because it's too horrific. Not how that works. Regarding the video, based on the state's argument to blur out the entirety of Eric Richins' body, defendant's motion to exclude is denied. Interesting. Regarding the color photograph of Eric Richins' body, the court finds it's probative of Eric Richins' time of death. It is. The jury may use the photograph to determine the veracity of the medical examiner's opinion regarding the time frame of which Eric Richins died. The court notes that the color of the photograph is washed out and not bright or vivid. The photograph does not show the deceased face, and there are no other inflammatory aspects, such as nudity, blood, or injury. The court finds no signs that the photograph would provoke a strong reaction to the lay viewer, the normies. Therefore, the probative value is not substantially outweighed. Okay. Okay. Because the autopsy photos and stuff are going to come in too. Not all of it, but some of it. And with the lividity, you can see the way that the blood settles on the body. We talked about lividity a little bit we zoomed through some of it, to be fair, in Banfield. And it was discussed with regard to like the blood drops and what have you, and then where the blood inside the body settles when the heart stops moving that blood around. We talked about it a little there. We'll hear about it more here because we're not going to be zoom in this trial. We're in it to win it, law nerds. Gavel to gavel. Zoom over of stuff we can't hear. We're not going to be zooming witnesses. This was the one that was on the docket. I don't know what this is. Motion to exclude the Sedona Mago life story. Defendant seeks to exclude a quote-unquote life story that the state alleges defendant drafted while at a retreat in Sedona. I want to go to a retreat. Law nerds. I would love nothing more than a retreat in Sedona. Sedona is fucking glorious. The content of the life story is probative of defendant's feelings about her marriage to Eric Richins. The probative value is not substantially outweighed by the danger of unfair prejudice. Defendant's motion is respectfully denied. Oh my God. I want to know what happened at the wellness retreat. I want to know. Sedona's amazing. There is so much more in this trial that we have never seen. We've seen a lot in this case. There is so much more. Law nerds, to be fair, she's a writer, guys. EDB's a talker. Kouri's a writer. You guys, she's a writer. It's called manifesting. When was she writing out the life vision of the life she wanted that didn't include her husband? Because that's what it sounds like. When were you manifesting life without the husband? Heather in the chat has corrected me appropriately. It's called self-snitching. Well, I mean, that's what Bruce Rivers would call it. Self-snitching, manifesting. Come on. Synonymous. Oh my goodness. I did not anticipate that there was a full like wellness retreat visualization life story. Put it on the list of things we're going to send out, Miguelina. Put it on the list. When we get to the life story from the wellness retreat, that's going in an app notification. Come on back, law nerds. Life story from Sedona. Wait. Was Sedona where Rachel Levis went for her wellness retreat? Was that in Sedona as well? I need to know. I just don't remember. Motion to exclude defendant's substance use. Defendant seeks to exclude evidence that she and Eric Richins ate THC gummies together. Okay, this is where the Utah of it all comes in, right? This is where it comes in. I am sure the defense does not want anyone on the jury that might judge Kouri for the fact that she was... The law nerds are not judging you over the weed gummies. There's so much else to go on. The weed gummies aren't a problem with us. But if the defense is worried that members of a jury may side-eye her and be like, girl, go to Swig, get a crumble cookie, shut the fuck up with your weed gummies. They might be concerned about how this might make the jury view her. I don't give a fuck, but they know the jury pool better than I do. This is not my decision to make. A Los Angeles jury is like, just one a day. How strong is it? I mean, like with breakfast and dinner, right? Like which weed gummies? And also, why aren't you just, are we rolling anything or like, what are we doing? A Utah jury, not the same. And this is what the defense gets to decide, right? Defendant seeks to exclude evidence that she and Eric Richins ate THC gummies together. Ma'am, you put it in your whole walk the dog letter. It's going to come up. Including an exhibit where the two discussed taking gummies together on January 15th, 2022, and that there were gummies in the home in 2022. No. If your defense is that he accidentally OD'd on the weed gummies, you can't turn around and exclude the weed gummies. You can't do both. So the defense wants to exclude that she and Eric had the gummies, that they discussed taking the gummies together, that there were gummies in the home in 2002. They were tested. They didn't have fentanyl. The defendant had a gathering on March 5th, 2022, where she drank alcohol and made references to taking gummies on Valentine's Day. Was that at home? Or was that at the cabinet installation? I have some questions. Okay, so she doesn't want the jury to judge her for drinking and taking weed gummies. I mean, ma'am, if you're drinking and taking weed gummies with your paramour, you're going to get judged for that. And then 3 days after Eric Richins' death, defendant asked CL for a quote-unquote hookup. Although a hookup could refer to many things, there is reasonable inference that it refers to illegal drugs or pharmaceuticals. After Eric Richins' death, defendant told detectives that Eric must have died from ingesting fentanyl-laced gummies. Defendant's demeanor on March 5th, the day after her husband's death. Is this the day that she throat punched her sister-in-law? Was she high when she throat punched her sister-in-law? I have so many questions. Defendant's demeanor on March 5th, the day after her husband's death, is probative to her reaction to his death and relevant to whether she committed the charged crimes. Evidence that defendant or victim ate THC gummies together in 2022, and that there were gummies in the home is probative of whether defendant's statement that victim eating a fentanyl-laced gummy is fabricated or credible. Evidence that defendant asked CL for a hookup is probative of her relationship with CL, including whether it existed, how close they were, and the types of things they interacted about. The probative value of the evidence is not substantially outweighed by the danger of unfair prejudice. Drinking alcohol is legal. Eating THC gummies, even without a medical card, is common and does not give rise to the heightened reactions that Rule 403 is meant to protect. Even the judge is like, meh. Like, meh. The jury's not going to freak out over this. Meh. Fair. So the judge is like, this is not the kind of thing that everybody's going to lose their mind over. It's not more prejudicial than probative. A robust voir dire will eliminate prospective jurors who may be offended by the use of alcohol or marijuana. There you go, Your Honor. The judge is like, hey, I'll let you yeet the people that are like, if somebody drinks alcohol, I cannot listen to the thing they say. The judge is like, fine. Jurors who can't listen to that evidence without thinking or judging or will unfairly their senses will be so offended, we'll yeet them. Look at how normal and rational that decision is. All right. If jurors are going to be super offended by this, we'll just get rid of those jurors. Fine. This isn't the case for you. Look at how just logical. We've learned some new things, but look at how logical. Motion to exclude evidence that defendant assaulted sister-in-law Amy Richins. Defendant seeks to exclude evidence that 2 days after Eric's death, she assaulted Amy Richins upon discovering that Eric had put the family home in a trust that defendant did not control. Defendant was charged with assault and wrote a letter to the Summit County attorney. Defendant moves to exclude the letter under Rule 901 and evidence of the assault under Rules 401, 404, and 403. The state has offered a non-character purpose for admission of the assault. You cannot have an assault put into a trial to say, look, this person punched that person, ergo, murderer. You can't do that. You can't put in evidence to show conformity therewith. But because they did this, obviously they did that. That's not proper in most instances. There are narrow exceptions to that rule, so asterisks. However, you are allowed to prove that Kouri Richins did not know that she wasn't inheriting everything. That's kind of a big point. Her lack of awareness, the Scotty didn't know of it all, is absolutely relevant. And her throat punching her sister-in-law when she found out that Eric changed his will and trust is a big part of it. Yep. The court says that the state has offered a non-character purpose for admission of assault or the assault to show the extreme reaction, either way, of defendant's reaction to allegedly learning for the first time that a substantial amount of Eric Richins' assets, including the family home, were protected in a trust. Yeah. Soup's relevant. Because I imagine that there was a whole lot of screaming, yelling, and then relevant. This evidence is probative of her murder to cause the death of Eric Richins for pecuniary gain. Murder for pecuniary gain, by the way, pecuniary gain is a special circ in California. The last time we talked about that was, I think, the Menendez case, when we've talked about the appeal process, that one of the special circumstances there was murder for pecuniary gain. Notwithstanding the non-character purpose, the probative value of the assault is reduced by its place in the overall evidentiary landscape, which includes other evidence that shows defendant's visceral reaction to learning about the trust, including that she broke down crying and that she had to be physically separated from Amy Richins, like had to pull her off of her sister-in-law. This relatively low probative value is substantially outweighed by the danger of unfair prejudice. There is substantial danger that evidence of the assault will invite the jury to make an impermissible propensity inference that if defendant is violent enough to assault sister-in-law, she is violent enough to cause Eric's death. The danger of this impermissible inference substantially outweighs the probative value. The defendant's motion to eliminate all references to defendant's assault is granted. So the interaction is allowed. The punching, not allowed. So the judge is tamping down the extremeness of the reaction. However, if defendant testifies, I imagine that we might see a circumstance where the door is opened for this. The court is correct on that. I think that when you get into this testimony, her behavior, short of the punch, is appropriate. Fair enough. We'll see if it comes in other ways. The prosecution's not going to talk about it in opening statements, and we'll see if it comes in. Maybe yes, maybe no. But you can't admit things that could be unduly prejudicial. And this is the first time we've actually seen the judge say this might be unduly prejudicial. And so we're keeping it out. Kate in the chat asked, is she going to testify? Her attorneys have said that she is intending to testify. Motion to exclude business deal regarding 299 East 100th Street property, Barney House. Defendant moves to exclude evidence that shortly before Richins' death, defendant agreed to seller finance the Barney House. Oh, this is the bestie. Oh. Put a 1 in the chat if you remember the story with the bestie. Put a 1 in the chat if you remember. Don't feel bad if you don't remember, but put a 1 in the chat if you were here. Were you here when we talked about the bestie last time? If you don't remember, if you weren't here, you get to experience it for the first time. Oh boy. Defendant moves to exclude evidence that shortly before Eric's death, defendant agreed to seller finance the Barney House to her best friend in exchange for a $45,000 down payment. 2, that the defendant used the $45,000 down payment to cover unrelated debts and was unable to secure a 30-year loan as promised, and the house fell into foreclosure. The foregoing evidence is probative of defendant's financial condition at the time of Eric Richins' death, which is relevant to defendant's potential motive to kill her husband for pecuniary gain. The probative value of the evidence is not substantially outweighed by the unfair prejudice. The state may present evidence that defendant agreed to seller finance the home in exchange for $45,000 and that she used the $45,000 to pay off other debts. The arguments the state may make and inferences the state may ask the jury to make based on this evidence are limited as described below. With these limitations on the evidence and arguments that may be presented, defendant's motion is denied in part and granted in part. Here's the tea. Here's the tea. Kouri told Bestie, if you pay me $45,000 down payment and then pay rent, I will secure the 30-year loan and then you'll make payments to it. And then it's like layaway for a house. And then as you're paying to the house, eventually the house will be yours. So even if you don't have like a 10% down payment or whatever, we'll take care of it. And this ended up being a substantial amount of money from Bestie or former Bestie. We're not sure, but a substantial amount of money from Bestie, like Bestie's savings. And then the house went into foreclosure because Kouri didn't have the ability to secure that kind of loan. I don't even know if she had the intention for to make that kind of loan. Took the $45,000 and put it to other debts. Well, Bestie, hubby, and numerous young children were living in the house that then went into foreclosure. Money's gone, house is gone. I understand that the defense attorneys are concerned that a jury is going to look at Kouri Richins and be like, we know you're on trial for killing your husband, but also, who dogs out their bestie like that? Like, what are we doing? But it does go to the financial circumstance that $45,000 she need to immediately go service other debts because she was drowning in debt. And it didn't matter where the money came from because she was grabbing at every last straw to try to keep it all afloat and could not keep it all afloat. That's what it properly goes to show. The defense is worried about everyone on the jury going, but your bestie though. That's what they're worried about. Motion to exclude business dealing bad acts. This is the limitations. Defendant moves to exclude a broad swath of evidence regarding her financial dealings that she asserts is being offered as evidence of other financial bad acts, including evidence regarding the financial crimes charged in the other case. The state argues that evidence of defendants compounding frauds, the gathering storm, if you will, to borrow from Murdaugh, is relevant to show that killing Eric Richins was her last resort. Suffocation. No breathing. Don't get... Sorry. We went full Papa Roach there. Because this is my last resort. I can't help myself. This was her last resort to avoid financial collapse, personal humiliation, and criminal exposure. To the extent, Your Honor, you're fucking with me. I rock the mic like a vandal, light up the stage, watch my jump like a candle. Come on. What are we doing? Stop it. We're just seeding song lyrics into the ruling. What are we doing? To the extent the evidence referenced in defendant's motion constitutes evidence of a wrong or other act under Rule 404B, it is being offered for a non-character purpose to prove motive to commit murder for pecuniary gain by showing the high acuity of defendant's financial condition at the time of Eric Richins' death. For that reason, the evidence is also relevant under 401. The court is not going to let this turn into a full fraud trial. A lot of those fraud counts are in another case, and the court actually parsed those out early on and said some of these fraud counts can go into these cases. Some of them are too far in time. And the ones that are too far in time need to go. And now they are in another case. So, whether evidence of defendant's financial dealings and financial difficulties falls on the impermissible side of a Rule 403 balancing test depends on the nature of the evidence and the arguments the state seeks to make based on it. The state may present evidence of the defendant's conduct that led to her becoming highly leveraged, exhausting her sources of credit, and on the verge of financial collapse. The state may show that the defendant's representations and documents she used to secure credit is inconsistent with evidence showing her actual assets. The state may also show that defendant was incurring new debts to pay old bad debts. Yeah, it was like a full fucking shell game. Or using one line of credit to service another, thereby increasing her overall indebtedness. All of the foregoing evidence is probative of defendant's financial condition and whether it was becoming less sustainable in the period prior to Eric Richins' death, which is relevant to motive. Given the importance that evidence of motive plays in a circumstantial case, the probative value of the evidence regarding defendant's financial condition is high in the context of the evidentiary landscape of the case, and that probative value is not substantially outweighed by the danger of unfair prejudice. Based on the admissible evidence described above, the state may make arguments regarding the potential personal humiliation and civil litigation that might follow if defendant was unable to maintain appearances, avoid foreclosure, and prevent financial collapse. It also goes to the argument of why is divorce not the option here? She was not financially in a place to sustain a divorce, and it could impact custody. They probably won't be able to argue that. But how was she going to pay for somewhere to live? How is she going to pay for anything? She was so leveraged. If they got divorced, she would have been in a crater of debt. And if they got divorced, she doesn't get anything from him. But if he died during their marriage, she did. Or she thought she did. So, the court says that it's part of the evidentiary landscape in the case. Based on the admissible evidence described above, the state may make arguments regarding the potential personal humiliation, civil litigation, and the fact that she was unable to avoid or maintain appearances, avoid foreclosure, and prevent financial collapse. On the other hand, the state may not present evidence that frankly shows uncharged, in this case, fabrication or forgery of documents, like the account statements for accounts that do not exist. Yes, kind of fake forge. The forgeries regarding that are in the other case. Emily, what forgeries? She was taking her husband's business's bank statements, like the body of it, and then like cutting and pasting her bank information at the top and the bottom. So it looked like the statement The body of the statement was coming from her accounts, but they weren't. They were coming from his accounts. It was a pretty easy to see cut and paste of the bank statements. Those are in the other case. So the state cannot show the uncharged fabrication or forgery of documents. Similarly, neither the state nor its witnesses may speak in terms used in the criminal code, such as fraud, forgery, or illegal. The evidence of such arguments fall on the impermissible side of Rule 403. Such evidence, opinion, and argument adds little to the probative value of the evidence regarding defendant's financial situation. Moreover, any probative value it has is substantially outweighed by the danger the jury will make the impermissible propensity inference that because defendant allegedly committed a financial crime that isn't charged in the case, she's likely committed other counts that are charged in the case. Because she is charged, let me go grab my charging notes real quick. Because off the top of my head, it is just not top of mind. She is charged with the false insurance claim and the forgery regarding the forgery. Sorry. 2 counts of the false insurance claim and the forgery regarding the false insurance claim. But she's not charged with the mortgage frauds and forgeries. In this case, they were severed into the other case. So they don't go to anything in this case. And because she is charged with forgery, you can't say, oh, but look at all these other forgeries, therefore this forgery. So the court is limiting it to showing the debt, but not always how you're getting to the debt. It is a more narrowly parsed ruling than what we saw in Murdaugh, right? That is up on appeal at the SJC, or not, South Carolina doesn't call it their Supreme Judicial Court, but the Judicial Court of South Carolina, or the Supreme Court of South Carolina, sorry. So the court is narrowing this down. While witnesses may point out inconsistencies in the evidence, witness may not make value judgment on those inconsistencies, such as testifying that defendant lied, misrepresented her assets, or was acting desperately, or words to that effect. That's going to be hard to narrow down. Because when you get to her interaction with her sister-in-law is allowed to describe it, but you also can't get into speculating at somebody's state of mind. And saying someone's acting desperately, isn't that speculating about their state of mind? Such value judgments may be within the proper realm of counsel's argument, but they are not evidence. Fair. Finally, the court notes that its foregoing balance of Rule 403 may change if, during the course of the trial, the volume and redundancy of financial evidence supports a finding that the marginal probative value of any additional financial evidence is substantially outweighed. So the court's like, we're not getting into cumulative evidence here either. We're not throwing a mountain of financial evidence into this case. At some point, it's enough they get the point. With these limitations and guidance, defendant's motion is denied in part, granted in part. If counsel needs further guidance on the parameters of this ruling, counsel may proffer its proposed evidence to the court for discussion outside the presence of the jury. That's reasonable. It's cautious. It is on the cautious side of reasonable, but it's reasonable. Some judges will not always skew on the more cautious side. This is skewed on the more cautious side of reasonable. Still reasonable, still proper, more cautious. Also, what the judge does not want is a financial fraud case inside of this murder case when those claims have already been severed out. They've been removed. Emily, you should have looked at how many pages this was before you started this morning. Yep. Should have. I didn't know how long this ruling was going to be. I should have talked less earlier on. Anyway, timestamps. Time is a construct. We'll fix it in post. Motion to exclude community service letters. Defendant moves to exclude evidence that on February 12th and 14th, defendant wrote letters on CL's behalf and represented that she had completed community service hours at Circle R Ranch. Miss Ma'am. The woman that you were asking for all the fentanyl, the woman you were asking to be the go-between with all the fentanyl, you were forging her community service hours because she already had cases. Right. You got to keep people out of custody when you need their help. Girl.
Bruh.
Come on. What are we doing? Because the letterhead and company were fabricated. Oh, we've gone beyond fake forge. We've got a whole fake motherfucking ranch. The Circle R Ranch. For Richins, right? For Richins? Ma'am. It's the ranch. We have a ranch. There's a ranch. The ranch in Mexico, the ranch in Utah, the Circle R Ranch. We have a ranch. Was this part of her Sedona life visioning exercise? Also, no shade to life visioning. Just it should include your own positive actions towards self-improvement, not murder. There's some I have some limitations in how you might vision what your life looks like. I would like to exclude the murder. Okay? You want to manifest a ranch, have at you. But the forging community service letters, I am presuming that is for court because we know that CL had other cases. CL had other drug-related cases. Needing community service hours is a very reasonable thing that you would need in drug cases. Oh no, boo-boo, I got you. I got you for the community service hours. For sure. You were helping at the ranch. The letterhead and company were fabricated. And because CL will testify that she did not actually complete community service hours, defendant argues that the evidence is irrelevant and prejudicial.
Bruh.
Evidence the defendant wrote community service letters for CL is probative of the nature and extent of their relationship, which is relevant to the state's theory of defendant's source of fentanyl. The first letter was written a day after CL allegedly secured drugs for the defendant. There is a reasonable inference that the letters were written as a quid pro quo. The probative value of this evidence is not substantially outweighed by the danger of unfair prejudice, even if CL testifies that she did not actually complete the community service hours. Right? The community service hours were bullshit. But do you remember how much the defense argued, nobody can show where Kouri Richins got this fentanyl? Excuse me. I didn't know there were fake community service letters. You guys, listen to me. Hold on. Listen, Linda, listen, Linda.
You guys, you don't understand. She is a millionaire, land baron, titan, rancher. Because the outfits are cute. And we like boots and mini cows and little horses. And it's so much fun. It is a ranch. We manifested. I said ranch. Obviously, there's a ranch. How do you not, get it? I went to Sedona. There are vortexes. This is real.
I mean, it might not be real in this timeline. So that's a problem. But maybe it's real in some timeline. Sure. But the Circle R Ranch is a delightful reveal that I was not prepared for. The fake fucking ranch. Also, the way that I would love to just have an animal rescue and let the horsies just run around. Oh my God. Emily, that's the most expensive undertaking. I know. I would give them a YouTube channel. I know. But the delight I would find. Horses are very expensive pets. Yes, I'm aware. Doesn't mean it wouldn't be fun. If I had $1 million, we would do the Circle EDB ranch. The law nerds could come visit. We could do equine therapy. You guys manifest. Let's manifest. It would be so great. We could all just come and play with the horses. The doggos run around. It would be fantastic. Okay. Sorry, I forgot we weren't writing what our life looks like in our if everything was possible world. And then you could just give people community service hours. I thought that community service hours had to be approved through the court. You can't just go somewhere and be like, "Oh, I did community service." There's a list of approvals for community service. You can't just go do it. My kid's senior project required more documentation of community service hours than this appears to. Oh, we could have retreats. We could do goat yoga. 100%. 100%. Obviously we need a ranch. Clearly. The Circle R Ranch. Not even a creative name. I thought you were a writer, ma'am. Can we not come up with a better name for the ranch? What did the logo look like? Dead ass. Was it just ripped right off of Canva? I bet it was. Okay. So, letterhead, fake letterhead, fake company, fake ranch, fake community service hours. Fakey, fake. The day after CL does the hand-to-hand transaction at the Maverick and Draper, then you get the here you go. Oh boy. Because the first letter was written the day after CL allegedly secured drugs for defendant, there's a reasonable inference that the letters were written as a quid pro quo. Yeah, there is. However, evidence that the defendant fabricated the letterhead and the existence of the company is unfairly prejudicial. Well, how do you splice that, Your Honor? I mean, how do we splice that she was writing off community service hours for not a ranch? How do you explain to the jury that this is fake without saying that there's not a ranch? This might be a little too cautious for me, Your Honor, in all honesty. How do you explain that it's a quid pro quo without explaining that Kouri Richins doesn't actually work at a ranch? Otherwise, the jury can sit there being like, but did she do community service? Is there a ranch? Evidence that defendant fabricated the letterhead and the existence of the company is unfairly prejudicial. These facts have little probative value to charges in the case, and the evidence will invite the jury to engage in impermissible character-based propensity analysis. Accordingly, the state is precluded from admitting evidence that the letterhead and company were fabricated. Then how does the jury know that it's a quid pro quo? I think that's too cautious because we saw this in Reed. They weren't allowed to talk about, excuse me. They weren't allowed to talk about where Forge is stuck in my brain. Not Forge, but they weren't allowed to talk about where the crash daddies came from. And the jury was like, okay, well, they had to come from somewhere. And then the jury assumed that they just came from insurance. And it seems in the first trial held that against the defendant. So if a jury doesn't know, thank you, Arca. Forge was really just lodged in the brain. If the jury doesn't know that, I mean, I guess if you parse it, Kouri Richins doesn't work at a ranch and cannot sign community service hours. Maybe that's how you get around it. But they need to know that the community service hour letter is a quid pro quo and that Kouri didn't have the authority to say that Carmen had done community service hours. I think that's a little narrowly parsed. I'm interested to see how this comes in. I think that's a little narrowly parsed. I guess we'll see. Motion to look, the judge is very much leaning on the side of caution in the benefit of the defendant, which protects a conviction down the road. But this is very much cautiously leaning to the benefit of the defendant. Motion to exclude March 19th call with Eric's friend. What now? What now? Defendant seeks to exclude a conversation that she recorded with BK, Eric's friend, approximately 2 weeks after Eric's death, as irrelevant under Rules 401 and 402. Defendant argues that the call depicts her as rambling and intoxicated, and that it is not probative of a fact at issue. I'm sorry. What? Why are you recording the call? Why are you recording the call? Why are you recording the call? The content of the call is probative. Oh boy. The content of the call is probative of defendant's thoughts about Eric's death, her finances, and the state of her marriage before Eric died. Her statements to friend can be fairly compared to other statements she made about those topics. Dude, don't drunk dial. And also, why did you record it? Like, she recorded it. Girl, why did you record it? This is a preview of trial that I didn't know we were getting today. Oh boy. Here I am being like, walk the dog, walk the dog. Is that a fucking wolf on a ski slope? Sorry, back to walk the dog and Orange Notebook. And there's a lot of recorded calls that I did not know that existed. Okay. My shoe fell off. The statements to Eric's friend can be fairly compared to her other statements she made about these topics. The probative value of the conversation is not substantially outweighed by the danger of unfair prejudice, as long as the state does not use the call to paint defendant as a drunk or point out that she may have been intoxicated. Yeah, no, they don't care about that. They care about what she said. And it sounds like they've already yeeted any jurors that are going to have a visceral reaction to someone drinking, and that are going to have a visceral reaction to someone using weed gummies. It seems like they sorted out all of those jurors, and they're just yeet. So you can't call her a drunk. Fair. In addition, the statements on the phone are not hearsay as long as they are not being offered for the truth of the matter asserted, but rather the effect that his words had on her and the context of her responses. Fair, because trying to listen to her statements on a one-sided phone call without the other side of the phone call doesn't make a ton of sense. Oh boy. So the phone call's coming in. Defendant's motion is denied. Motion to exclude child from wedding photo. Based upon a stipulation from the state, defendant's motion is moot. Oh, that's right, because they got married after they had their first kid. Children's faces are generally blurred. It's also fine to crop it entirely so that you don't see that there was a child in the wedding photo at all. Fair. And the state is like, yeah, we're not doing that. That's not what we're here to do. Motion to exclude defendant's medical records. Defendant seeks to exclude a document seized by a warrant from defendant's home that indicates defendant consulted with a doctor in Mexico in April 2022 about having bariatric surgery. What? Oh, this is not where I thought this was going, because there were other medications in Eric Richins' system of the type that Kouri Richins had a prescription for. Now that's going to come up. Kouri Richins had a prescription. That prescription was in Eric's system. That is going to come up. I did not think that this is where this was going. No, but I mean, I don't think anybody cares. Is the state seeking to exclude? Is the state seeking to introduce us? Oh, maybe they are. Wait a sec. Wait. He died on March 3rd, 2022. When did she go to Mexico to talk about weight loss surgery? Is this like a month after he passed? Okay. The surgery's not the thing. The behavior after the death is the thing. He died on March 3rd, 2022. Okay. I mean, nobody cares if you want to have weight loss surgery. Being a newly widowed mother with 3 young children and then going to Mexico to try to have a cosmetic surgery, I can see where that might be relevant. All right. The defense seeks to exclude that the defendant consulted with a doctor in Mexico in April 2022 about having bariatric surgery. Defendant seeks to exclude the document as irrelevant under Rule 401 and privileged. The state argues the purported medical documents may become relevant in rebuttal if defendant presents evidence or argument that defendant was grieving and focused on her children in the aftermath of her husband's death. According to the state, considering or having bariatric surgery is inconsistent with that claim. I mean, it seems like the recovery time on this would be tough, right? I imagine her mom would probably live with them, but I would think that the recovery on this would be kind of intense. According to the state, considering or having bariatric surgery is inconsistent with this claim. The court finds that the document may become relevant in rebuttal for the reasons argued by the state. Okay, that's fair. Defendant's conduct in the wake of her husband's death is probative of whether she committed the charged crimes. The probative value is not substantially outweighed. This is going to be interesting to see. A lot of you are saying it is at least 6 to 12 week surgery. I don't know. We have seen photos of the defendant. I don't know what the qualifications would be. It seems that in the States, she probably would not qualify for like any of the bariatric surgeries, but that's not what I was expecting at all. However, I'm interested to see where this goes. We'll see if this comes up on rebuttal, but it's interesting to travel out of the country regarding surgery, any kind of surgery that would require recovery time in this period of time. However, I am also, Chad, I am with you that I am thinking this is probably more of they say bariatric surgery, which in my mind is like stomach surgery. I am curious if this was more of tummy tuck, lift, all the things, because she was getting ready for her new life. Like she was getting a little wind under her tail. She was ready for a little bit of a tune-up. So I'm curious what this is. However, I think the argument stands that she was ready to be the hot, grieving widow. I wonder if it ties back to how she was manifesting her life in Sedona, that everyone was going to feel sorry for her. B, she was going to be the center of attention, and everyone was going to say how strong she is and how good she looks and what a tragedy it is and what a wonderful mother she is. And however do you do it? Because you're just the beautiful young widow of this beloved, successful businessman, and your beautiful life and your beautiful house and your beautiful children and your beautiful stomach. And and that this was the vision. This was not true, horrible, disgusting, drag you into the gutter so you can't breathe grief. This was a whole new world. This was the attention. This was the role. This was the, but I look good in black and I'm going to bleach my teeth. And everyone is going to praise me and pay attention to me and love me and talk about how well I'm doing. Versus what grief looks like for many, which is horrible and painful. So I can see the state's argument that she's just girl bossing her way. Oh, Joe Jersey said, Emily, even Brandy got a rejuvenated vajayjay after her divorce. Look, I have no problem. You get divorced and you want to have your, new me moment, have it. No problem. The murder is the part that I have a problem with. It's the murdering. It's also the inconsistency. If your spouse suddenly dies and you find them unresponsive in your home, it is a fucking nightmare. This is nightmare shit. No one wants to find a loved one deceased. No one. Especially completely out of the blue. It's awful if someone's on hospice. And and it's still awful. This is nightmare fuel. This is not, oh, I'm going to go to Mexico and tune up the bod so I'm looking better in a bikini. That's not. A month later, if you get divorced and you sign your divorce documents and are like, let's go, boobs up, go get you. Fine. This is not that. This is not that. This is not that. I am also a very good post-divorce wing woman. I am. I've got you. I've got you with a Honey Love bra. I've got your boobs up to your clavicle. I got you looking good. I got your hair later, but we're not going to need it because I've got you hydrated so that we can go out. I got you. However, this is not that. This is not that. This is not that. Nope. You want to get divorced and go get your best life? Do it. This is not it. This is not it. This tracks with the state's theory of the case. The state's theory of the case is she wanted her new life with her new man and to forget about all her debts. This tracks with that theory of the case. This does not track with grieving widower. No. Yep. That's not this. That's wild. Me hyping myself for something scary, boobs up, let's go. Same, Julie. Like, let's go. Let's go. We got it. It is. It's a whole thing. It's the whole thing. We're like, all right, pick your tits up. Let's go. This, though, is a wild reveal, right? That when you are grieving, and everyone handles grief differently, but the thing I have seen most common is that you are spending a significant amount of time trying to breathe and move and putting one foot in front of the other. It's horrible. And the post-divorce celebration, new me, new life is very inapposite to what the sudden death of a spouse experience seems to be. And I understand putting on a brave and strong existence for your kids. But even that, you are going to need someone there to pick you up and help you keep doing that. That's not let's go out of the country and get cosmetic surgery. It's just not. people can keep moving through incredibly difficult things, but the energy it takes to keep moving, where would the energy be for this? I can see the energy of not sobbing in front of your kids all the time. I can absolutely see it. But where is the energy for this? Because you're not going to have energy for yourself. You will have energy for your kids. You're not going to have energy for yourself. It's just so different. Trying to keep your world from falling apart for your kids is not the same as joyfully going through a divorce, if there is such a thing, and then being like, it's time for, my, hot girl summer. She had 3 little kids. Also, this is wild. So, for all of you who have grieved and have struggled to breathe, A, I feel you. B, I feel you. And C, if you're sitting on this jury and you're listening to this, are you just like, what? This is more sideways than the children's book for me. For sure. Oh boy. Oh boy. Oh boy. Also, any surgery can be risky. If you just lost your spouse and you have 3 very little kids, it feels to me like maybe that would be scary. Like maybe for a while, non-elective surgery would feel scary. Maybe emergency surgery would feel scary, but maybe elective surgery would be scary. Because emergency surgery is scary. Necessary, medically required surgery is scary. How would this not be scary? Like, how would you not be like, I can't do that to my kids? Like, what if it's the 0.001% of something that goes wrong for my kids? What if something goes wrong? Okay. So, all right. That's new. Auntie Time in the chat asked a very good question. How do you get a new vajayjay? There are rejuvenation procedures. I'm already in trouble with the powers that be today because Doggo, but there are rejuvenation procedures. There are lots of different types of rejuvenation procedures. There are procedures. There are also hormones, and there are many things. Also, since we were talking about weed, there are THC and CBD adventures, and then maybe you don't need any to have any considerations about any of that. It's an option. It is an option. So, this is wild, and I had no idea. And we're not even done yet. Cranber, what did I walk back into? Everything. Taco talk. Taco talk. All of the things. So, we're not done. We have one more ruling to go through. I am now way over time where I thought I was going to be today. Sorry, Team Baker. I know I have a ton of work I need to do. Look, Brenda and her beaver support this conversation. And if you are a new member, there are a number of members-only live streams where we explore that book and others. I'm going to just leave that there. If you are a new member, go there. Go explore the things. There's another ruling. I'm going to try to distill where we're at before we get to the next ruling. Going through Judge M's rulings on all the motions in Limine illuminated some of the things that might happen in trial, including that the walk the dog letter is coming in, the journaling in the day leading up to and the day after Eric Richins' death is coming in. But what we have learned, aside from the children's book, which also the cover of which is coming in, but Kouri has maintained that she's a writer. She's a writer. She had a very, very well thought out novel. And the walk the dog letter, even though it says page 1, the walk the dog letter was just a part of that novel. She's a writer. We also learned that there were written pages in a cupboard that seemed to be notes that Kouri took after her conversation with law enforcement of what she told them. That's coming in. But that's not the only thing she wrote, because there's also a life story that she did while on a retreat in Sedona that seems to envision a life not including her husband. And that is coming in as well. But that's not all. There is also discussion that might come in rebuttal that Kouri Richins had gone to Mexico in April following Eric Richins' death in March to explore cosmetic surgery. And the defense wanted to keep it out. The prosecution says, look, this does not track with the story of a grieving widow who cannot move forward. This tracks with somebody who's like, new me, let's go. And so that might come in the rebuttal case. We also know that quite a lot of jail calls are coming in. And there were quite a few new reveals in the court's ruling today that we read through that I was surprised about. So there is going to be a lot in this trial that we did not know. There's also a recording of a call with Kouri and one of Eric's friends happening shortly after Eric's death that is also going to come in, because Kouri talks about her finances, her feelings about Eric's death, and more. We're going to hear a lot of recordings in this case, and it'll be interesting to see how Kouri addresses those recordings that she had tried to keep out, or her lawyers tried to keep out, if she takes the stand in this case, which her lawyers have indicated in previous court hearings that she intends to do. Now, people tend to change their mind when they look at the jury. But also, if all these recordings are coming in, and the jail recordings and more are coming in, I think it makes it more likely that the defendant's going to want to explain. However, on the other side of that, there is some things that will come in rebuttal if she testifies that she really might want to keep out. And now we need to take a look at the compelled conversations. Remember, the defense wanted the court to force the prosecution to turn over the cell phone text message conversations because they accused the prosecution of intimidating witnesses. And there was headline after headline after headline that the prosecution's intimidating witnesses. And we looked at that and went, okay, so they're telling the witnesses they've been subpoenaed, they need to come to court. If they don't come to court, they can be provided a locked place to stay and a ride in a cop car to court. And I did take issue with you can't force somebody to go to an interview on a subpoena. Fair, but you can force them to go to court. That does happen and can happen. And so when we covered all of this, it was, is this a threat or is this a, you've been subpoenaed, if you don't show up, this is the next step? Really, we needed more context, I think, and we didn't have it. We also speculated, and this was our speculation, that at least some of those text messages were with Kouri Richins' mother, who is on both the state and the defense witness list. That is pure speculation based on the content and based on the fact that they were immediately screenshotted and given to the defense. So the judge ruled on that yesterday. and we're going to go take a look. We're going to take a look before we wrap up because there's a lot that Team Baker needs to do before we go to trial on Monday. On Monday in Mountain Time, which is exciting. I'm excited. I'm excited that we're not on Eastern Time. Everybody in Pacific Standard Time is like, oh, finally, a trial that's not on Eastern Standard Time. We're in Mountain Time. We're getting closer. I know. It's a little more reasonable for all of you in different time zones, and we'll be streaming later in the day for all of you that are on the other side of the world that are like, oh, good, we don't have to do trial at 3 a.m. my time. I know. It's going to be better. I'm excited too. So we will, once I see what times we're doing, and I have some emails about that because we're going to have our own feed, I will let you know. But I suspect most days we will be starting around 10 o'clock Central. That's where I think we will end up landing, which will work well. It'll give us a little bit of zoom room. It'll be great. So let's look at the court's ruling on the motion to compel the cell phones of it all. You know, these defense attorneys are like, where's our proctor? Give us our proctor. Every defense attorney from here forth is going to be looking for the proctor in their case. And they're not wrong. They're not wrong. Because after you've seen what happened in Massachusetts, how can you not wonder, like, what's going on in some of these other cases? I don't think this is it, but I understand. All right. The judge kind of spills the beans there a little bit in the title. Your Honor, we try not to do spoilers in the title. Ruling denying defendant's motion to compel disclosure of communications with trial witnesses. Spoilers, Judge M. However, we were spoiled that the other ruling wasn't put under seal, so we actually got a little bit more of a peek into all the things that were discussed in the non-publicly available hearing. Before the court is the defendant's motion to compel disclosure of communications with trial witnesses. Defendant requests an order requiring, quote, the disclosure of all recorded calls, voicemails, texts, or any type of digital messages from the prosecution team or any of their investigators and or investigators from the sheriff department and or private investigators or process servers with any witness subpoenaed by the state to testify at trial of this matter and or any witness identified as defense witnesses. Did I not say this was horrifically overbroad and was never going to get granted? I did. In response, the state asserts that it has reviewed its investigators' witness communications consistent with its Giglio obligations. These are the Brady obligations. Is there anything in there that's potentially exculpatory? And as a result, made 5 disclosures involving a single detective and a single witness. Okay, so they gave over 5 things. They're like, here's this. I'm sure we'll see it come up. The state did not identify any additional material that must be disclosed under Giglio. Having reviewed defendant's motions, the state's opposition, and defendant's reply, the court is not persuaded that, as of the date of this hearing, the state's disclosures are incomplete or that the state otherwise failed to disclose information that is material for its impeachment value related to state's witnesses. Because defendant has not shown a sufficient or pervasive basis for the relief she seeks, defendant's motion to compel disclosure of literally fucking everything, that's not what it says, but you get the point, is denied. Yesterday. Denied. Mindy is reading my mind and my emails. Mindy, does EDB have quick bits recap of this case so I can catch up before Monday? We do have case briefs over on the Emily Show channel, and I am going to do a summary for Monday in the podcast. It's going to be a part of the podcast with a, like, what you need to know. Yeah, we are 100%. We have a very full playlist here, but I think we've put together a Kouri Richins playlist on the case briefs. And if we have not, we will have one up for you. So yeah, we'll have both. And yet there will still be stuff that we don't know because this case has been full of surprises. And there's more things in here than we expected. So when we get to this, excuse me, when we get to this trial on Monday, we are going to, we're going to have opening statements on Monday. We're going to have initial jury instructions. There is a hearing in court today. There is no recording that I can find of that hearing today. Pool Camera said they are not covering today's hearing. If local media covers it, I will share it with you guys. Or we will summarize it on Monday's Emily show. We are also going to have our own court feeds. I'm very excited. If there are glitches with the feed, there's only so much we can do, but I'm excited that we have a little bit more control. But it's also something new for us, so the tech will be teching. So we'll see. But I'm very excited. I cannot wait. I cannot wait to be in another trial with you. And I don't know if we've covered a trial that we have covered for such a long period of time pre-trial, because this trial got delayed numerous times. By the time we started covering Murdaugh, we started covering Murdaugh before he was charged with murder, but then it went to trial actually pretty quickly, quicker than I expected. And we just have followed this for so long, thinking it would go to trial much closer in the period. And 3 years later, here we are. So this one's been on the docket since 2023. And we have followed it all the way out. Petty cakes, Boone. No, I didn't follow Boone in the pretrial stuff. I had an eye on it, but we didn't follow the motions and the filings and the hearings. We just jumped into Boone as a jury. I'm like, I've heard about this case a little bit. We've seen that it was going and we just jumped in. Depp Heard, same. I covered the UK ruling and then we kind of jumped in. I really think that this is one of the first that we have covered from the time of arrest all the way through. Rust we covered pretty close in time, but it went to trial much faster. So even Rust didn't have that length of time. So I think this is one of the only ones we've covered from arrest all the way through. We did a few Boone letters before trial, but not many. Not nearly this. This has been, what about Karen Reed? I didn't cover Karen Reed before trial 1 at all. I said, we'll cover it when we get to a jury, and we started covering it when we picked the jury. Girardi, we didn't cover the trial because it was federal. Koberger, we covered, but it didn't have a trial. If it had a trial, it still went to trial faster from arrest to trial than this one. What else? No, a lot of the other trials, we've really not had such a long journey to get to trial that I can think of. Murdaugh took a little bit, but not quite like this. This has been substantial. And Cardi B, we jumped in trial after the fact. So Murdaugh went to trial pretty quick, all things considered. That's the one that's coming up close as this to something that we covered this long and then we see a trial on. So Donna took a while, but we didn't cover Donna much before trial. I think we started covering Donna briefly when her first trial got kicked. So like a year. We've been following this one for 3 years. So I think this is the longest. I'm going to go back and take a look, but I think this is the longest from initial coverage to trial. We've covered a lot of things for a long time, but they didn't all go to trial. I think this is the longest we've waited for a trial. That's how it feels to me, that this is the longest we've waited for a trial. But also, this case there's been, the preliminary hearing, which we haven't covered a ton of preliminary hearings because a lot of the cases we cover have been indicted. The preliminary hearing, the bond hearing, there's been a lot that happened in this litigation. So, with all of it, we are going to be in trial on Monday. I'm going to answer a lot of your questions. Let's get to some questions, shall we? Because it feels like we've been covering this for like 85 years. And then yet we haven't seen enough of Judge M. It's like, we've been covering this forever. We just want more Judge M. The lawyers in this case are, I mean, it's a murder trial. Fun is not the right word, but the lawyers in this case like do their lawyer stuff. But then also when the court's like, really now, they all go, okay, Your Honor, sorry. This courtroom has been running with professionalism. We have seen the lawyers, for most things, work really well together. And everything has run fairly normally, though the facts of the case and the things that are coming out are wild. This case is run pretty normally and respectfully, professionally, and it's nice to see. So let's get to some questions. A lot of you have a question about a goat. I can't. Our stream will get yeeted. We will get yeeted. We will immediately get yeeted. We pushed it this morning. Like, We salt and peppered the shit out of this stream this morning. We went full ask for forgiveness, but we will be yeeted. And I do want the replay to stay up so people can see it. I absolutely do. Jen, the law nerd, good to see you. Is there a possibility of it, the EDB Air lanyard being available again? We are working on more lanyards. It will not be the exact same one for a while. We do not have an EDB Air restock in the books. We have a few other launches before, but it is something we've been asked about a lot. We have other lanyards that are on our mind for some other launches. But EDB Air has been heavily requested, so we might weave in an EDB Air down the road. Next launch is going to be, we've been working on next launch since before this launch. I'm very excited. I love our launches, and every time we start working on something that is so much fun, it's so difficult for me to wait from like idea to getting it into your hands. It's so hard. Krista Good as he said, watching with my 6-month-old sleeping on me, that's the best feeling. He rolled off the bed yesterday, so my mama heart is feeling all of the guilt. He's fine, but he gets showered with affection. Thanks for the company, law nerds. Look, kids do wild things. They will be fine. You will carry more scars from your kids being little than your kids will. You will remember these things more than they will. Every time I had to take one of the kiddos to the hospital with broken arms and broken wrists, and it was always wrists and arms, the heavy weight it left on my heart, and my kiddos were like, I have a cast. Great. Can we stay on the swing next time instead of being like, I can lean all the way backwards? No, can we not? Please. There was a summer where T and G both had broken arms from different things. It's fantastic. It will hurt your heart more than them. It will. And it will stay with you more than them. But they do learn. Migraine 101 said, just bought the koozies. Please consider dropping beer koozies. A lot of us collect them for fun and want to rep the law nerds. The can koozies we have should fit your standard size beer can. But we have more koozies in my wish list and others. So yes, we do. Angel said 20 months of Sidequest. Love them. I know somebody in the chat is going to be like, oh my God, I can't believe there's timestamps, everybody. Y'all know that, but the Olympic floof, I know some of you in the chat saying like, Emily, why are you talking about a goat? There is a goat that interceded in the Olympics as well on a ski jump run. And we cannot play another Olympics video or yeet because Olympics. I cannot wait for the day where I can just do commentary in addition to law with other things without getting yeeted. At the moment, we cannot, unfortunately. We cannot. Let's see. Stephanie said, my Dotson is mad about this coverage. Yes, The wolf running down the slopes. Can I pet that dog? Is on repeat in my brain right now. It's a great meme. Also, for those of you that don't know the Can I Pet That Dog meme, it is a very small child wanting to pet a bear and being very insistent about why can't I pet the dog? I want to pet the dog. It's like, if not friend, why friend shaped in a meme with the greatest little Southern accent. Love. It's a great meme. Emily said, what's the story behind the Bloodworth clip mentioning the law nerds? Emily, I'm so glad you asked. Should we just play? Should we play it? Have some of you not seen where the Docket 214 clip comes from? This one? Hold on. This one?
Docket 214, but every law nerd on the internet calls it the walk the dog.
Do some of you not know the origin story of this? Okay. Emily, I'm so glad you asked. And some of you that do know the origin story are like, fuck it, roll it anyway. Roll the clip. We'll roll the clip. One more side quest, and then Emily's going to go watch hockey. All right, one more side quest. Emily, where are your notes? Let's see. I have my notes. It's in my notes. Thank you, law nerds. One more side quest. All of you are just like, literally, do it. Perfect. Let's see. Where did I put the Docket 214? Oh, I don't see it in, let me refresh my notes because I do not see it in my notes. I have the link to that video somewhere. That is not the video. That is the walk the dog letter. Hold on. Where is, let me go grab it real quick, law nerds. I thought I had the link from the video. It's just going to take me a second to grab it, but it's on my channel. So easy to go grab. And I'm not going to mess it up. We're not going to yeet ourselves watching our own videos. So that's not going to be a problem. Let me just go grab it from our Kouri Richins playlist because I actually do fairly well remember which hearing it was from. So we're going to go grab that. I'm pretty sure it's this hearing. Yep. All right. Let me cue this up real quick and then we will play it because I'm just going to need to keep it on I'm going to need to keep it just on a loop for us because we're going to need to reference back to this during trial. So if you guys are asking, Emily, where did this come from? The motion to suppress hearing went through the walk the dog letter and was talking about the walk the dog letter and talking about where the walk the dog letter came from. And so the prosecution was going through the jail search to find what became Docket 214, the walk the dog letter. And so when they were talking about it in court, the prosecution said this. So we are going to Emily Inception for a moment, and we're going to back up in this evidentiary hearing. So we are jumping back in time. What date was this? Let me just look real quick at the video. January 29th, 2025. When we talk about how old this case is, this clip is from January 2025. Yeah. All right. Let me move me because we are going to go take a look at me and me. So there's, past me, present me. It's me. Let's go to court. Oh my God, our video is so much more clear now. God, I love it. Nothing I did wrong. No need to be defensive. Just answering the questions you ask me, which not everybody can. I'm just commentating. All right, girl, keep commentating. Do, because even if you know that, there are people who, when questioned, are still going to be like, wait, what?
Sergeant Barrett, you're familiar
It takes
with what I mean when I say
effort.
the walk the dog letter, right?
We're on cross.
Yes. Docket 214, but every law nerd on the internet calls it the walk the dog letter.
I'm sorry, Mr. Bloodworth. What did you say?
When you searched...
Okay. So the reason that the judge the reason the camera pans like that is because the judge's order was that you cannot show court staff. And so when there is one camera and the rule is that you cannot show court staff, you end up with this weird panning back and forth. So Bloodworth walks up on cross-examination during the suppression hearing and asks this deputy if he is familiar with Docket 214, but every law nerd on the internet calls it the walk the dog letter.
Sergeant Barry, you're familiar
It takes
with what I mean when I say
effort.
the walk the dog letter, right?
We're on cross?
Yes. Docket 214, but every law nerd on the internet calls it the walk the dog letter.
I'm sorry, Mr. Bloodworth. What did you say?
When you searched...
Mr. Bloodworth. Mr. Bloodworth. Sir? I was and am kind of flabbergasted because, again, it is not the like, oh, I am like closed captions on top of closed captions. Hold on. That's really annoying. I am still surprised that this happened. Little Queen said, you seem so chilled about this, EDB. The hearing had happened before we watched it. And the chat was a little spoilery. So I knew that something was coming. And I am still very surprised. But I was stunned. And a number of law nerds, no shade to the law nerds, out of excitement, the law nerds had clipped this across the interwebs the day before we got to cover it. I was stunned and still kind of am stunned because, Mr. Bloodworth, I would like to know exactly what you said. Because Mr. Bloodworth, yes, we do all call it the walk the dog letter. True. So yes, girl. Chat has made the hearing. But I think we're going to need to we need to roll that back again. Back that up a minute. We need because Mr. Bloodworth, sir. We need to back that thing up. We need to we need to boogie on back. We do. Tell me you're a law nerd without telling me you're a law nerd in court. Accurate. Because yes, sir, we do in fact refer to it as the walk the dog letter. To be fair, it does say one of us. It does say walk the dog at the top. It does. And all of you in chat are again saying one of us. Yeah, you were doing same in the chat, right? Same. Mr. Bloodworth, there it is, sir. Whoomp. There it is. Same. Motion granted, Mr. Bloodworth. We got to back up just a little bit. Mr. Bloodworth, you're right. We do.
Sergeant Barry, you're familiar with what I mean when I say the walk the dog letter, right? Yes.
We do.
Docket 214, but
I am delighted.
It is. Calls it the walk the dog letter.
I was talking over it. I rewound it and then it's a vibe. It's still a vibe. And kept talking. I mean, fair, naturally. Yeah.
With what I mean when I say the walk the dog letter, right?
Yes.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
And there it is. Also, how rude that we don't get to see Bloodworth's face while we're getting a shout out. How rude. It's a moment. All of you saying Bloodworth needs a law nerd shirt after trial, chat. After trial. But it was just such a natural reference. This is the most if you know you know situation ever. This is an if you know you know. And if you don't, you don't. So that is where the Docket 214 came from. It came from an evidentiary hearing in the past. We have also had our channel referenced in other filings. And I was like, they are in fact talking about us. But this case has not gotten, there has been like spurts of coverage, but it has not yet gotten the kind of coverage that you see in a lot of cases. It just hasn't. It will. You will see coverage pick up as we get closer to the end of the prosecution case is generally what we see. People will cover opening statements. And then as we get to the end of the prosecution's case, interest will pick up. As we get into the defense case, interest will pick up. If the defendant testifies, interest will spike. And then people will want to watch closings and verdict. The Lawnards are going to be here every day. But this is slated for a 4-week trial. Interest will grow over time. And it just depends on what else the news cycle is doing. Because honestly, there is so much other stuff going on that, yes, locally in Utah, this is going to have daily coverage, I'm sure. But it might not break through into like lots of coverage until almost the end of trial. If it does, it's just going to depend on what else happens in the news. If there is like breaking news about Nancy Guthrie the day that Kouri Richins testifies or something, she is going to be gutted that she is not the top of the headlines. 100%. Because we have seen the jail calls and transcripts where she's just talking about the media coverage in this case and talking about her thoughts about the media coverage in this case. Yeah. So there's so much else going on that we will be there. Lady Narek said that Emily was horrified that Judge M sees what the chat says about him. I have concern that Judge M did not want to stream this case because the friends, family, spouse of Judge M might have been like, okay, look, every Lawnard on the internet calls this the walk the dog letter, but what I don't need is every Lawnard on the internet calling Judge M daddy. So can we not? That's my conspiracy theory. And I don't think that we can impose that rule. We do have a no name calling rule. However, sometimes it is difficult to rein in the love and admiration. So we try our best, but there's only so much one can do. We try our best. So that is my conspiracy theory as to why Judge M was hesitant to stream the trial. It was because those in Judge M's life is like, do you need 800,000 people on the internet calling you daddy? And I can imagine Judge M being the, humble king that he is just like, I just want to do my job. Can I just do my job? I just want to do my job. I mean, it's fair. It's fair. And he has been on the avalanche recovery advisory board and stuff. So he might also, in fact, be a crash daddy. It's adjacent at least. So yes, I was a little bit mortified. Liza said, no way they mentioned how many subscribers. No, exactly. It was to the exact number of, there are channels with, X number of subscribers. And I was like, it was like 802 or 3 or 4. It was an incredibly specific number. It was not a rounded number. It's not like there's channels with 500,000 subscribers on the internet talking about this. It was not that. It was dead ass exactly the number of subscribers we had at the moment. And I was like, oh, that's us. That is exactly us. That is exactly us. It was not there are channels with hundreds of thousands of subscribers on the internet. It was exact. And I was like, oh, us, you're talking about us. Okay. You're talking about us. The thing is, what you can say about the Lawnards is the Lawnards thirst respectfully. They stand competence. I mean, the fastest way to get stand by the Lawnards is to be competent and then having a fantastic voice. And, we love that. We love that. We love the standing competence. It just is. But yes, we were we were referenced more than once. Mod Princess says there's never just one more side quest. I know they're like Pringles or Ruffles or whichever is like, it's exciting stuff. All right, let's see. Oh, it's Susan. This is such a sweet comment. Thank you. I'm so sorry for your loss. The Law Nerds are a group that has experienced more grief than their fair share, but it's Susan R. said, I lost my partner unexpectedly in January. I'm so broken. Susan, if I may offer, and I'm going to anyway, but if I may offer, you are not all the way broken because you are here with the Law Nerds. And Sarah Boone kind of ruined one of my favorite analogies, but yeah, you are heartbroken. You are not broken. You are still here, and we appreciate you. She said, thank you, Emily, for describing this grief with so much understanding and compassion. You're welcome. No, we're not all going to cry together. Emily, no, we're not. People are working. But I feel you. A lot of us have had more than our fair share of grief. Grief breaks our heart. It does not break us because we are still moving. We are still moving. But it's hard. And that's why some of these arguments sometimes in court just piss me off so much. It's what was hard. It was hard for me as a DA too, to not just be like, as if that's what somebody's doing. It's hard because you just want to stomp your foot and be like, this is bullshit. Because come on, bullshit. It's bullshit. And anyone who has been through such incredible grief looks at that statement and is like, nah, no, that's not it. That's not it. So it's hard. So hugs, Law Nerds. Grief is awful. And then new grief pulls up old grief. Things that are not even grief, things that are not your grief pulls up grief. It's tough. And it is the ever-presenceness of it is really tough, which is why for many of us, it is hard to take a step back from some of these cases and pull ourselves back out of it and objectively be like, what are you doing? Because the thought process that we are trying to understand in these cases is so difficult to wrap your head around. What are you doing? What are you doing? How is this the decision making? And it's horrible. So I get it. I absolutely get it. Let's see. Ronald said the Doggo section of the stream was naughty and will be on the naughty chair during the replay. It is. It's definitely on the naughty chair. Worth it. Katie said, my dad was a civil engineer. If you asked how anything worked, he started with how the wheel was invented. Well, Katie, I think your father would probably say that is the proper way to start. You must begin at the beginning to have a proper understanding. It's a very, very large. Why are there vultures? They're very big. Very close to my window. I was like, okay. But yes, they would say that that's the proper place to start. Subpoena Colada. This is such a fucking serve of a handle. I love it. The I'm not a cat lawyer, the Subpoena Colada, all of it. 10/10. I bought a Law Nerd hat and I love it. It fits nicely. It's great when having a bad hair day and it's very flattering. Thanks, Em. You're welcome. I love our hats too. And I wear them all the time because I am light sensitive. And so if I am in an environment where I can't control the light, I need a hat. I need a hat. I need a berm. And so I wear them to everything. I try to remember to not wear the one that says not fuckery to like my kids' school. I mean, but it's black on black. So it's fine. It's going to be fine. Allie Katz said, love having ADHD, EDB, and hockey simultaneously. I would do that if I wasn't trying to stream because then I would just be like, squirrel, squirrel, squirrel. EDB, you're going to regret whatever you're about to say would be the title of my book. It'd be an autobiography. Yeah, I'm about to regret whatever I'm about to say. True. Automatic Dramatics at EDB, how do you feel about your tattoos now? I could do without mine. I'm sorry to hear that. How do I feel about my tattoos now? That I do not have enough time to go and get more of them because they are lonely. My tattoos are lonely. They need more friends. So that's where I'm at. They need more friends, but I have not had time to think it through. I do ponder for quite a while before I tattoo, but there's more space. There's just not enough time. There's not enough time. There's just more space. So yes, they need more friends. I wonder how many of his former coworkers will show up as a surprise rebuttal witness if that former coworker question gets testified to. This is an excellent point. The surprise rebuttal witness has become a feature of the streamed trial, which is wild. It's wild. Let's see. Okay. I think we got almost all of our things. Let's see. An update on the AP claims. I have not had a chance to have a conversation about the conversations. The claims all got released. I am told there was a conversation. I do not know what that conversation was with the AP yet about what they can and cannot put in their little like automatically ding you portal. But we're going to have to wait and see what happens with this trial because I have media access to a feed, my feed that I am using. So the AP hit me and it seems like quite a lot of others because they had put it through their automatic system. If they try to do it this trial, I am going to lose my mind on them. But there are conversations that need to happen today and tomorrow as we head into trial. But it's part of the reason that me having our own media access makes so much sense to continue to be like, no. So, that's our update. I will keep you posted. I want to know the rest of the conversation. I just don't know it yet. And when I do, I will share with you what I can share. I imagine that conversation, because that conversation moved up the chains pretty quickly. And I imagine that conversation was, look, if you put things into this automatic system improperly, you are going to lose access to that system. We'll see. Lyndon said, you've activated my trap card. Mm-hmm. You guys, everyone that was on stream yesterday saw lawyers can be petty. Don't give me a reason. Because the reason is you. Look, man, if you want me to be petty, I'll be petty. I'll get there. I don't petty a lot. But if the Associated Press is going to go around slapping copy claims on everybody, it's time to slap back. Fine. You started it. You picked the wrong folks to mess with. Legacy media thinks that they are going to pick these fights and that these fights are going to go well. They're not. Go focus on why you don't have viewers. You go do you. Leave everybody else alone. We do our own stuff. We don't fuck with you. Don't fuck with us. But if you start fucking with us, yeah, that's not going to go well. Like, literally worry about your own side of the street. Stop worrying about what everybody else is doing. It's wild. Instead of worrying about, whatever you've got going on, it feels so focused on just pulling everything else down. Stop pulling everything else down. Do your shit. But there is automatic systems that legacy media has access to that creators don't. I have a lot of feelings on that. We'll talk about it another day. There are reasons that outlets should have access to systems that can make sure things aren't being improperly used. But if they improperly use those systems, there should be consequences. Because if a creator, and the blur between a creator, a media company, and whatever is substantial blur at this point, if you are going to abuse those systems, there should be the same consequences there would be if you were categorized as a creator. Because it's pretty easy to say, oh, we don't own the copyright to this. Do not automatically go copy claim these videos. But if you put it in the system to say that it's yours and then let it automatically claim all the videos, that is abusing the system. And there are so many systemic abuses that I cannot do much about other than keep telling everybody that we can make change, we can think for ourselves, we have options. But this one I can do something about. So don't make me channel all the rage in your direction, because I'll do it. Sometimes there's nowhere else for it to go. I'll just take all that energy of the things I can't change and focus it on the thing that I can. And if that thing that I can is you losing access to a system so you can go copy slap all the creators, sucks to suck. We'll just do that. But if it doesn't happen again, then everyone benefits because it is stopped. Because I know so many creators all got hit by the same shit. And the fuckery of it is, Emily got activated. The fuckery of it is, they weren't the pool camera. It wasn't their video. It was Court TV's pool camera. Court TV didn't do this shit. Law and Crime did this shit once and then they never did it again. TMZ tried this shit with my channel once and then they never did it again. And actually that made really good content, so I wasn't even all that mad about it because it was amazing content when it happened. But it wasn't even yours. So it was a willful fuckery. And you know better. And now I know that they know better. And if it happens again, they will see a level of glee in my petty ass being pissed off. So we'll see what happens this trial, law nerds, but we know that they know. They know that they know. And if it happens again, there is a very thorough paper trail of their abuses of the system. And it seems that the next thing would be for them to lose access to the YouTube system if we don't need to take it further. So I can easily channel my energy that way. Sure. Let's see what happens. I'm optimistic that it won't, but we have a very thorough paper trail. So if it does, then it is a willful violation. And that seems that they should just be yoinked, doesn't it? Seems like it. So all the copy strikes were removed off of my channel. It sounds like from others, their copy strikes got resolved pretty quickly. So if we see it happening this trial, I would be disappointed in their decision. But also, there is a lot of dopamine in the come at me, bro energy. So we'll see. We'll see what happens. You know, it also at one point, YouTube's going to be like, girl, come on now. You're arguing with us over the copyright system. You can't show the doggo. You cannot roll the doggo on the channel, girl. You know, come on. I maintain that it was for fair use and commentary. And we did all of the fair use and commentary. However, the powers that be are going to be like, ma'am, fair use and commentary. It was also newsworthy. It was also related to a case that we were covering. In my defense, I was left unsupervised. I just got confused between the walk the dog letter and the dog. That's all. It was just, oops. Just oops. So when you don't see any ads on this stream, you will know why. And look, I have no problem sharing monetization with the copy holder, but also, doggo. It's still not the AP's video, so it's fine. All right, law nerds, you guys are the best. I have definitely got to go. We've got lots to do before trial. If you do not have the Law Nerd app, we are going into trial. You are going to need the Law Nerd app. This is your trial bestie. When we start streaming, we let you know very close in time to when I'm streaming. The time on the feed is like a gathering time. The push to the app is like, and the lights have dimmed for the band to come on the stage. Right? There's the ticket time, and then there's when the lights go down. On the feed is the ticket time. When the lights go down is when you get your Law Nerd app notification, if that makes sense. And invariably, there will be things that happen in court before the things we want to see, and we will send you out push notifications. When we hear about the Sedona life story, when we hear about the Paramore, we might need a Paramore counter for this trial. I need one of those little click counters. We're going to need a Paramore. Dr. B, we're going to need a Paramore click counter because we're going to hear about the Paramore. And when opening statements start, because Monday is going to be opening statement day, but there are going to be instructions to the jury and other things. So from the time we start to the time that opening statements start, we will send another push notification that opening statements are starting. We send a push notification when we come back from lunch, when we get into cross-examination, stuff like that. So get the Law Nerd app, built it for you so that you can know what we're doing and when we're doing it. And some of you are saying the door's open time. Exactly. The door's open time versus the starting. There's always going to be a little buffer room. And what I see from most of you is like, all of you are like, okay, I know what time we're about to start stream. And then I've got a little bit of a buffer. So it gives that extra like boost of urgency. It's perfect. Law nerds, you are the best. I will see you for trial on Monday. All right. Take care of yourselves. Take care of each other. Me earlier today. Oh, Dr. B, don't worry. We just have a few documents to cover. Get your snacks. Get ready to hydrate. And get ready for trial. I'll see you guys on Monday. We're going to drop a podcast before trial, so it's going to be a little early. And we've got a lot of new stuff coming for you in trial. I'm very excited. All right. See you guys Monday. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.